Testing. Yes. Appeal of which year? 2021, 20th. Bail applications we are hearing only on Mondays. Because we have 2011 FCS, 2014 criminal offense. Criminal appeal. What do you want? What do you want, sir? You want to argue bail application or appeal itself? Dankanta scene in the 18th. One word is enough. 20th. Yes. Item 38. What do you want? It will go to December 1st. If you seek, we told you, once you get bus, you have to board it. Otherwise, you will get your bus after 2 months. That is the pressure we have.
Sorry, sir. Any date which
39 at request of Land Council for Appellant. 38, right?
Item 38.
Request of Land Council for Appellant list on 4th December.
That's item number 61. Reverse purpose petition.
60?
61.
What do you want?
Have it at 150.
What for?
90 kilometers parking. Regarding prestige of 90 kilometers parking. Last week it had come up at the lordship directorate. Bail application something posted directorate.
What to do?
The top of the list tomorrow or 1 o'clock.
The Dilsner bomb blast case is disturbing us. What to do? So this week anyway we are going to complete the hearing. We'll see. Let it be there.
Item 94 may be taken up next month.
Next
Month.
when do you want?
Item 94.
What do you want? There is no bail application. Appeal is
Yes,
of
next
20th.
month it may be taken up, Your Lordship. I want time, 2 weeks time I want.
What for?
For final arguments or
Final argument we will hear in March
Okay.
2023.
Okay.
Item 94. Record was the list on
have to get the documents.
6th March.
Okay.
One of you, not both of you.
Item number 187, Lordship.
What do you want?
Lordship, there is a small correction in the order copy, Lordship, which had to be listed in.
187.
Yes, Lord.
Now, what do you want?
For being mentioned, one small variation in the order copy, Lord.
Tomorrow. For being mentioned tomorrow.
71.
What do you want?
Matter is the Supreme Court, there is a matter.
Supreme Court?
There is a connected matter.
Correct. Matter is there in Supreme Court. What do you want now?
There is a mediation on
20th
of this month.
We are aware.
Yes, sir.
What do you want now?
Kindly post of.
Did you inform other side?
No, I haven't.
Then without information, can you make a mention at 10:30? Is it proper on your part?
I have not.
Leave it. Yes.
Lordship, item 75.
What do you want?
Parties are present, your Lordship. Custody of children, your Lordship.
Custody?
Children, your Lordship.
There is delay petition. We'll see. Let it reach. We'll see.
Same renewing my request.
We thought
Yes,
we may finish
I board on
that Dilsner bomb blast case.
any
But
date.
this week we are going to complete
Any date convenient, Your Lordship, for that next week.
14th. 14th in the top of the list. Both matters, right?
Yes,
14th top of the list.
I'm ready.
So by hopefully by Friday, we are reserving the matter. So there won't be any special bench from Monday onwards,
And
Tuesday onwards. That is the problem.
I'm ready.
36th day today.
It's long.
Ah, very important. Yes.
Obliged.
చెప్తారు లేదు రిటర్న్ ఆఫ్ వివరణ చూద్దాం
Item 1, R5 business review.
ఈ అమ్మాయి చాలా ఉంటుంది ఈ అమ్మాయి వచ్చింది ఎస్ఎస్ IA 1 of 2023 is dismissed. List of appeal on 20th December. Yes.
Item 2, motion of another party person.
Yes, sir. On what ground you are challenging the allotment?
Lord, this land logistics has been given against to the law. This land logistics are given to the International Arbitration Center against to the law.
Against the law.
Yes.
What is the law according to? What is the violation?
There are specific, several Honorable Supreme Court judgments are there that the free land allocation cannot be done. It should be definitely given through the public.
What is the allotment letter?
Allotment, this is GOMS number 126, page number.
Page number? Page 39, is it?
Yes, 40 million.
What?
Yes,
GO 126, right?
GO 126.
26/12/2021.
Yes, madam.
Please read.
In the reference once above, an MOU entered into by the International Arbitration Mediation Center Trust, Hyderabad and Government of Telangana. Accordingly, the trustees of IAMC has requested for allotment of land for establishment of International Arbitration Center, IMC at Hyderabad. The government, after careful examination of the matter, hereby order for allotment of government land to an extent of 3.7 acres at plot number 27, survey number 83 of public 1 at Raidurg village, Sherlingampalli, Gangara district for establishment of International Arbitration.
Free of cost, right? Free of cost. It was allotted.
Free of cost.
But only one condition is there.
My lord.
It should be utilized for the purpose for which it has been allotted, and other terms and allotment shall be informed separately.
Yes, madam.
What are the other terms of allotment? So according to, there are no other terms,
Yes, madam.
right?
Yes.
This is only GO.
Yes, madam.
Uh,
And moreover, 3 crore rupees operating expenses is also granted by government of Telangana.
Where is that?
It is in next.
There is a separate GO.
Yes, madam. Next one. This is page number 45, madam. GORT number 365, dated 16th July 2022.
3 crores 96 lakhs 8,189.
No, this is in the second paragraph, my lord. Finance Department, wide their budget release order above, issued a budget release order for an amount of 3 crores to the registrar of
So
High.
this is according to this allocation of 3 crores is also against law.
Yes.
Which law, which judgment?
Then this is absolutely a private institution, my lord. It's not a government body. And as per the constitution, only poor people are entitled, or housing schemes or industrial developments. These are all entitled only in public auction. They have to purchase. But this land has been given on free of cost. And a well furnished office accommodation is also provided, my lord.
Mr. Arindra Prasad, you have to file counter. You are appearing for 1, 2, 3 or 4 also?
All the respondents.
4 also.
Advocate General will appear for
4.
official,
4.
only official respond.
4 we will order notice. That request. Sorry. Advocate General is accepting.
Yes.
And Advocate General is accepting notice. Then Advocate General accepts notice on behalf of the respondents and the seats time to file one notice to 4th respondent, personal notice is granted. List on 21st December. 4th respondent.
Okay.
5 days in filing. Who filed FC? One second. Challenge is to the order dated 1st May 2023 in IA 596. Right? 10,000 rupees. What is the amount awarded? 3,000 rupees per month. Then what is the problem? IA 2 lo notice to respondent, personal notice is permitted, and counsel for petitioner is also permitted to serve notice on the counsel appearing for respondent in FC vote number 11 of 2020, pending on the file of family court, third additional district and session judge, Nizamabad, list on 28th November. No, 28th and 28th. Dispense with application, 6 weeks, same.
No, please, this appeal against order of acquittal. In fact,
Who is the appellant?
appellant is the son of disease.
Complainant or defendant?
Complainant is the son of the disease person.
Leave, we have already granted leave.
Leave was granted.
Appeal వచ్చేసి admit registration call for the record.
Okay.
Sorry.
Wait, please, your lord.
Legal aid.
No, my lord, this is wrongly, my lord, declared a legal aid, my lord. This appeal is filed by accused number 2, my lord, in SC number 143 of 2021. My lord, the A1 convicted for life, my lord, the A2 convicted for 3 years, 324. For that reason,
So anyway, trial court might have granted.
yes, my lord, 30 days, my lord.
What are the conditions imposed by trial?
My lord,
10,000 or 25,000?
not
I
aware.
will say 2 or 10,000. What is it?
That agriculture is not.
Agriculture. Appeal వచ్చేసి admit registration call for the record.
My lord, fail should.
6th March.
My lord, 30 days, my lord, it is
అదే
going.
చేస్తున్నాం మీకు కాలేదు.
Sorry.
324 కదా. ఇక అయ్యే 1 of 2024 వచ్చి yesterday's matter. You are seeking 3 months.
Yes, your lordship. 9th, it is an operation.
2 months we have already granted.
Yes, your lordship, he is getting treatment, your lordship, and admitted, and this month 11th, he is
Surgery.
having surgery.
Yes,
your
surgery.
lordships. For abdomen, your lordship, heart
madam.
problem.
3 months. Huh? Why don't you get in? We will extend. According to her, 11th is the date of surgery.
It will receive on 2/9. Second.
What is the data for order?
Yes, Your Lordship, but when,
We'll extend this by 2 more months. Meanwhile, get instructions. 1/20. 1/4 of 2020. It is. We have extended by 2 months.
Oh, blessed.
Data them.
in this, Your Lordship was directed to get the instruction regarding the health condition of A1 and A15, Your Lordship. For that, I'll get it by 1 o'clock. And I'll ask about the specific overtax on A1, A2 and A15.
A1, A2 and A15.
Okay. For that, I'll make submission.
So we will call this matter at 120. 120 position. Pass over.
For one humble submission on the plate. So this paper book is actually we have collected paper book from the PNBs, but it's not.
Paper book declared. So what about you?
I have received the paper book because the paper book
Manakku
name is in the.
In which appeal you have received paper book?
Final appeal, Manasema, for this appeal, it's
Mari. ఈ appeal లోనే వచ్చింది.
1188 1194 1359 and 170.
yesterday I have reminded the section people also, my lord, that I have collected this paper book, it has to be put up in the.
చెప్పండి ఏదో ఒక appeal. Yes. 120.
Acha.
Yesterday's
What-
matter, you
Why
were
it was urgent?
health ground. Health ground, Your Lordship learned.
This is also at 1 minute because doctors they said that they'll come by 11:30 after they will come to the hospital.
120. 120.
120.
This is also
10 and
maybe passed.
Yes,
over.
sir.
10 కదా.
A3 is antecedents, that is also maybe passed over.
Pass over. Yes. Well, 12 and 13 separate the circulation question.
Which is too much.
షార్ట్ లేదమ్మా థర్స్డే ఆర్ మండే కూడా లేదు. ప్రభాకర్ సార్ది వింటాం మేము, మీరు చెప్పండి. యూఆర్ రెడీ?
I'm ready.
You are appearing for
I'm appearing in this, your lord, is
You are
54,
appearing for
13,
13.
item 13, your
You
lord.
are accused.
Item 13 is the A1, your lord.
A1.
A1.
So you are appealing for A2, na? A2, na?
What is it? It's not connected.
ఏ అక్యూజ్డ్ మీరు అపేర్ అవుతారు అని అడుగుతున్నాం. బండిల్ కూడా లేదు. వెరీ
It is not connected, your lord.
కనెక్టెడ్ కూడా కాదంటారు.
It is not connected.
ఒకసారి రెండు బండిలు ఇవ్వండి.
Role is different from the. Is a A1 alone convicted in this.
1 second.
Role is yes. Death of the daughter of this
అయ్యే 1/2023 బెయిల్ అప్లికేషన్
jail application.
ఫైల్డ్ బై
Lot is the booklet is ready. I think.
ఫైల్డ్ బై
Filed by A1, your lord. Your lord is
బాబు.
Rambabu. A1 to A3 were tried. Your lord is not collected the booklet in this.
కలెక్ట్ ఇట్.
Yes.
20th.
Yes. Yes.
Request of land council for apply. Just on 20th.
Because in this, your lords, all of them turned hostile, except the extrajudicial confession made before PW 11, your lords.
Collect paper book, both of you. Monday, sorry, 20th.
Much.
I received paper.
This also paper book is
First bail application was dismissed, right? This is
first
second
bail application dismissed, your lord, is whether the record is
Lower court record we have not received.
your lord is
20th or 4th? 20th or 4th?
fourth, your lord.
At request of land council for appellant, list on 4th in the meaning of this decision, call for the government board below, prepare paper book, put up. Yes.
And 16. Ready?
షార్ట్ పాస్ అవర్ ఉండదండి. మధ్యాహ్నం బెంచ్ ఉంది కదా, రెండు కనెక్టెడ్. వాట్ టు డూ, టెల్ us. We are also under pressure. 16 పిలవండి. 16 ఏమండి? 16 లేడు కదా. 16 వచ్చేసి నన్ అపీల్స్ ఫర్ అపలెంట్ లిస్ట్ ఆన్ 29th January. Yes. Paper book వచ్చింది. నన్ అపీల్స్ ఫర్ అపలెంట్ లిస్ట్ ఆన్ 1st January. Need to collect paper book.
Yes.
Yeah. What is the offense?
So this is the case of collection.
Maximum.
So
What is the age of the victim?
age of the victim was 6 years.
16. 16.
6.
6 years.
What should?
It is the sole accused.
So let's say the and the judgment was dated on 5th of July 2018.
Victim is PW2. FSL report is there. Medical examination, final opinion, potency certificate. Where is the age certificate? On what basis they have determined age?
No such a certificate was established.
Read PW2 evidence, victim evidence. I am studying in first class, Satyasai Vidyalaya, by staying hostel.
Studying in first class in Satyasai Vidyalaya but staying in hostel. PW1 is in process. Before being to hostel, I used some.
Don't know who is with a friend. I'm very interested. This and this wife and parents of parent of can be parents of who is the doctor?
Dr. PW.
PW?
6.
Not the rule of 24. Eight one. Yes.
Project medical examination is solely based on the FSL report. Also, if there is no external.
Even doctor's evidence also PW6. Okay.
It is solely based on the clinical examination FSL report. Also.
Hmm.
Page no 40.
Hmm?
Page no 49 of the FSL report. It's 58.
49. Please read.
An examination external genital and normal not bleeding no discharge. Present labia minora and labia majora normal. FSL report shades no evidence of semen, chromatosis, blood stains, and foreign body in the living system.
He is the accused is the father of Yadama, right? Accused is the father of Yadama.
So,
Father of Yadama.
father of the other.
Yes, madam. Keep it.
Your Lordship, according to the exhibit P8 and exhibit P6, according to P8 also, your Lordship, basing on the clinical examination and RFSL report, in my opinion, sexual assault cannot be ruled out. and it's been supported by the doctors and nurses. The recruiter is on the age of 6 years. But Evan was also implicated in this case, Lordship, because
Why?
there was a dispute regarding the financial loan
Between?
between the victim's father and the appellant Lordship. Lordship, we finally got
1 second, who is PW1? Victim's father. Let us read cross-examination first. Cross-examination of PW1. Page 10, page 10.
page 10 of the bill. I'm working in GHMC since 3 years on contract basis. The victim was almost 2 months old baby at the time of death of my wife due to jaundice. At the time, parents of the accused and the mother used to look after my daughter. And also, she used to attend her work at business. The victim girl was brought up along with the 4 daughters to the accused. Accused used to help me financially rupees 100 or 200,000. It is not to be funded that I have invested 7,000 to the accused. I have no dispute with the accused. It is not to be funded that the victim girl was thrown in the house of the accused. I brought the victim girl in the house of the accused while I went to attend the death of the father of my supervisor. It is not to suggest that I alone was living on footpath and the victim girl used to live along with the family of the accused. My duty timing supplement is it is not to suggest that I had a quarrel with the appeals on 14/7/2016.
Thank you. A year 2 of 2022 heard so and so and learned assistant public prosecutor is a, we will pass orders in the bail application. Madam. So, Monsieur, right?
I can answer. Will your boost? I can actually there.
What's in under booking? 20th or 4th? At request of land council to appellant list on 20th. In the meanwhile, registration call for the record prepared by the report. Lakshmi Raj. Number is Lakshmi Raj.
I can,
Paper book we have not received.
But I notice, I have filed
Field
the,
application dismissed.
yes, notice. Notice, last occasion I have
So,
given the
we have
evidence
granted bail to A5.
A5 and wanted to hear the
This
matter.
application is
Notice I have filed the depositions I have filed here.
so IA1 of 2022 by all 5, right?
Yes, Lord,
We have granted bail to only A5.
A5.
In respect of others,
You notice, is a case where the incident was taken place on 16/7/2017
according to,
in the fields.
there are no specific overtax. However, we have received, we have not received bail. Refer this application.
That's, the motive behind this incident is, you notice, the land dispute. The accused land dispute, you notice. The accused filed civil suit, you notice, that was decreed in their favor. You notice subsequently, the deceased filed appeal. In the appeal, you notice the judgment was reversed, decree was reversed. And against which you notice the petitioners, that the accused filed further appeal before this in High Court and it is pending. At that stage, you notice when they interfered and in the fields, you notice the incident was taken place. You notice when they tried to cultivate the land, which is in the position of the accused, deceased. The deceased, you notice. And at that time, you notice the incident was taken place as prosecution case. You notice in this case, PWs 1 to 5 are the eyewitnesses to the incident.
PW 1 to 5.
1 to 5 are the eyewitnesses. All of them are family members.
There is no independent witness.
No, you'll notice, as per them, you'll notice the neighboring cultivators have come and seen the incident, but nobody, they were cited as witnesses, but nobody was examined by the prosecution. As per PW 2 and 3 specifically stated in their evidence. Now you'll notice I come to the overtax, you'll notice attributed to the accused. You'll notice all the eyewitnesses attributed overtax to A1. A1 bet the deceased 3 blows on the head of the deceased. And all of them, you'll notice stereotyped. And A2 hit the
Against A1.
A1.
There is no specific overtax against A2.
Against A2, you'll notice they stated A2 bet with an axe on the back.
Correct.
But as per the doctor, you'll notice there is no injury on the back.
Hmm.
The injuries attributed to A1 were present on the head, but the injury attributed to A2 on the back side of the and the back of the deceased was not there as per the doctor.
No, A2 gave a hit with axe.
On the back.
It's on his back.
Back. Notice for that, just
Who is the doctor?
doctor at page 46, you'll notice my candidates, PW 12.
Dr. P. Ramohan.
Yes, Lord.
Deep cut injury over so and so with open skull.
Occipital region and
Deep cut
left
injury
arm,
over so and so.
scapula,
Associated with
ear and ear.
scapula.
The 4 injuries you'll notice found on the deceased.
4 injuries.
4 injuries. All of them are on the head, near occipital region and near the ear.
A3.
A3, no tax, no tax was attributed to A3 to A5. Notice, just I read the evidence of PW1, you notice for
Yes. Page number 1.
page number 1, you notice
16.
page number 2, you notice I read
One
the
second,
page number
one
1, you
second.
notice for understanding the case.
PW5 is also an eyewitness, right?
Yes, PWs 1 to 5 are the eyewitnesses.
Sir, please come to page 16.
16.
16. 13th line from the top.
Yes. You notice A1 gave a hit on the three times on the head of the deceased with axe, and A2 gave a hit the deceased with axe on the back. As a result, the deceased fell on the ground. All of them stated like this only. A3 and A4 have also gave a hit on the hit with the handle of axe to the deceased, and A5 bet the deceased with stick.
Therefore, we have granted bail to A5.
A5.
But A3
and A4 also you notice no injuries on the, as per the doctor you notice there are no injuries on the person of the deceased, on the body of the deceased. Therefore, the participation of notice as per going with the attributing the overtax, notice participation of A2 to A5 is doubtful, because though overtax was attributed to A2 on the back, there is no injury as per the doctor. Even as per the witnesses, you will notice A3 and A4 bet with stick portion of the axe. You notice, I don't know why they used stick portion by holding, because you notice that as there are no injuries, they have improved their versions, and to shoot the prosecution case, they deposed before the court. And further, you notice, just I read some of the portions, you notice PW2. Page 6, you notice we can.
Page 6. Page 6 of the memo file.
Page 6 of the PW2's evidence. You notice cross-examination. I am a graduate. I did not accompany PW1 to Ukunurpalli police station to give report. Accused persons are cultivating the disputed land since 15 years. accused persons are cultivating the disputed land since 15 years prior to the incident. My statement was recorded by the police on 17/7/2017. I read my statement recorded by the police. Accused persons belonging to my community and they are not my relatives. It is true, I stated to police that accused persons are my relatives and they are cultivating and disputed land since 35 years. It is true, I stated to police that deceased was not knowing about the land in survey number 86 situated at so-and-so. LW 4, 5, 6, 7, 9 and 10 were present at a distance of 50 yards away from the scene. Your Lordship, these are all adjacent cultivators, but these witnesses were not examined by the prosecution because the incident was happened in some other manner. Therefore, Your Lordship, because of the land dispute, Your Lordship, all of them are implicated. The incident, they have not come up with true version of the case. Therefore, Your Lordship, at this stage, Your Lordship, by going with the attribution of overtax, Your Lordship, A1 overtax were attributed to A1. Therefore, Your Lordship, remaining entitled for bail. That is my
It's your lordship.
limited.
According to the all the PW 1 to 5 are the eyewitnesses, your lordship. According to the evidence of PW 5 on page number 16, A1 hit on 3 times from the head of the deceased and acts with axe, and A2 give a hit to deceased with axe, give a hit, not any lacerating injury is there, your lordship. That's why in doctor's evidence there is no injury mentioned in the back side of the body.
Please come again.
A2 gave a hit to deceased with axe, just a hit it. That's why there is no lacerating injury at the backside of the deceased body. Because according to the doctor's evidence, it is argued by the defense counsel that
Then please come to page 12.
page 12.
Page 12, PW 4 evidence. A2 gave a hit with axe to the deceased on his back.
Back hit.
Even
No lacerated
The
injury.
argument
No,
is A will be this, otherwise no. Don't worry.
Only hit. Due to that he fell down. But there is no injury received at the back side of the body. Only hit the deceased. No lacerated injury, no any other injuries are. That's why it is not mentioned in the PME logic. According to the doctor's evidence also, on page number 46. Page number 46. I should last paragraph. I should PMA report and appoint all the injuries are antemortem in nature. Exhibit P9 PMA report. Approximate term of death is of the disease was period to 12 to 24 hours. Period to my examination. The cause of death of disease was due to hemorrhagic shock. Secondary to multi-organ injuries. Antemortem. The above injuries might have been caused with a sharp edge object. The sharp edge object is with the A1 unit. And A2 also is having sharp edge object and the recovery is there. As a result of the accused, recovery of the weapons is also there. And it is supported by the eyewitnesses PW1 to PW5.
That's all?
Yes, sir.
Yes. Any reply, Mr.?
even notice as per PW5 also, you notice it on the back. It is there on same page 16. A2 gave a hit to deceased with axe on his back. Back is there. Yes. But there is no axe injury on the back.
That's all? That's all?
Yes.
Senior ఏదో హింట్ ఇస్తున్నారు. Third Sri P. Prabhakar Reddy, Land Counsel for Petitioner Savil Complaints, Land Assistant Public Prosecutor, Mr. IA 1 of 2022, wide order dated. This application is filed by A1 DFA seeking bail by suspending the individual judgment. Mr. Wide order dated 10/10/2023. We have granted bail to A5. Considering the fact since the only allegation against
Lordship,
ఒక్క నిమిషం.
Lordship in fasting.
Dismissed. IA1 of 2022 is dismissed. Next item.
My only last case, Your Lordship, in respect of injuries were not attributed to them. At least in respect of A3 and A4, Your Lordship.
You have passed an order, detailed order.
Sorry, my
You
lord.
know.
Sorry.
Sole accused, right? Next matter, 302 is the offense.
Your Lordship, the offence is under section 302. Your Lordship, the incident was taken place when the two brothers were quarreling for the sharing of the amount, Your Lordship. At that time, the deceased intervened and Your Lordship,
So this is the consequence.
yes,
Is there any eyewitness?
eyewitnesses are PWs 1 and 2 are the eyewitnesses to the incident. The PW1 is the father, PW2 is the Your Lordship's mother. Even as per them, Your Lordship, they are not the eyewitnesses to the incident, actually. In fact, Your Lordship, they did not state before the police with regard to seeing the incident. Subsequently, Your Lordship, they
Did you go
include
through
the,
the deposition of PW1
yes, Lord.
recorded in Telugu? Both chief and cross.
Yes,
Entire Urdu words typed in English, in Telugu.
yes, Lordship.
So that is the effort made by the trial court, district judge. చదవండి ఒకసారి PW1. ఉర్దూ అర్థమవుతుంది. There are two eyewitnesses, PW1 as well as
PW1 and 2 are the eyewitnesses. Yes, Your Lordship, at page 13, Your Lordship, and before going to that, Your Lordship, I highlight that
PW13 is page 13.
PW1 in the cross
English
examination, it is not true to suggest that I am for the first time stating that hearing their quarrel, my son went there. I was calling to my son to come back. Alimuddin bet Saifuddin on his head with a stick from behind. That is one thing. Notice me kindly say next one. You notice at page 18. This is in respect of PW2. It is not true to suggest that I am giving false evidence before the court for the first time. Alimuddin and his brother Saddam were quarreling near their house, so and so. You notice for the same, you notice PW14, you notice may kindly say at page 65.
Who is he?
65, PW14.
Who is he?
PW14 is the investigating officer who recorded the statements of the witnesses. Lordship, my kindly page 64, line about 10. It is true that PW1 did not state before me that the deceased went after hearing the quarrel between the accused and his brother, and Jawruddin called him back and the accused hit him on the head from behind and the deceased fell down on the ground. Notice it is true, he is stating before the court for the first time. And it was not stated before the police. He did not state in 161 statement. And similarly, Lordship PW2. It is true that Gaushia B, PW2, did not state before me that Alimuddin is the accused and his brother Saddam were not Alimuddin. notice is the brother were quarreling me at their house at Haveli at 8 p.m. and their bike was burning. I had gone there and that her son came with her and she told him why he had come and was taking him back. When the accused hit his son on the head with a stick, reaching over her and that her son fell down and blood came out of his mouth and nose. You notice all these things you notice not stated before the police. First time they are deposing before this honorable court. Therefore, they are not the eyewitnesses to the incident as claimed by the prosecution. You notice father and mother. In fact, you notice there was a quarrel between the brothers with regard to the sharing of the amount, and you notice the deceased interfered as per the prosecution case. And then you notice the accused interfered between them. One of them you notice bed behind him, but there is no injury on the backside. And further you notice they are not the eyewitnesses to the incident. That is the one. That is my submission, sum and substance of this
Yes,
case. Your Lordship.
Is your worship PW3 is also an eyewitness, your worship. The brother of the deceased.
Brother of the deceased.
I mean, he clearly, apart from
Hmm.
1 and 2, he clearly stated, narrated the whole incident, your worship. PW3. From the third line, it has been
Even for that you notice I submit. PW3 also you notice for the first time he stated before the court. You notice that is also it's in page 65. You notice line about 8 you notice. PW3 did not state before me that he was present at the scene at the time of incident.
PW4 also.
PW4 also did not state before me that the accused and his brother were quarrel.
They were not eyewitnesses.
They are not the eyewitnesses to the
Yes,
incident.
ma'am.
Your Lordship, PW3, he states, clearly states about the incident, your Lordship. Along with that, your Lordship, this rough sketch of the scene of offense, your Lordship. That is on page number 73, rough sketch. Scene of offense. 75.
Yes.
I'll read 74, your Lordship. We are the above said panchas attended in front of the Syed Shamsuddin house at their village on the Samana police. Here CI Zairabad town and complainant Syed Zavaruddin were present. On inquiry, it came to the light that on 6/12 night so and so Syed Zavaruddin brothers, namely Syed Alimuddin and his brothers, were quarreling themselves on the issue of DCM sold amount. Meanwhile, Syed Safiuddin, son of Zavaruddin, intervened and rescued to extract them, but says that Syed Alimuddin keep previous grudge in his mind and hardly bits Syed Safiuddin with sticks with intention to eliminate. As a result, Safiuddin sustained blood injuries, severe blood injuries on his head, then shifted to Safiuddin to government hospital for treatment, and while shifting him to NIMS for better treatment, on the way Safiuddin was entered. Therefore, the Pachas examined scene minutely and not found crime stick which was used during the commission of the offense. From scene towards north side, there is a Syed Zafiruddin house. Towards south side, there is the Syed Shamsuddin house. Towards east side, there is the Syed Alimuddin house. And towards west side, there is Gram Panchayat building. In this, your lordship, they are not says, but one thing I want to find out, your lordship, that according to the evidence of all the witnesses, there was a fire because the
There was a
fire because he burned the vehicle, your lordship. That is not there in the scene of offense. I could not count it.
sir.
Sir, even in the exhibit P1, you'll notice both brothers were quarreling. And you'll notice the deceased intervened. And one of the brothers, you'll notice bet. Notice for that, there is no eyewitness to the incident. It was happened. PW1, you'll notice, gave a report in the police station after the death. Your Lordship, immediately he didn't go to the police station and Your Lordship is trying to see the first information report.
67. Page 60. Page 67.
67. Sixty-seven, Your Lordship, it was given at 12 noon next day.
Hmm.
Your Lordship, incident was taken place at about 8 o'clock in the night.
8:30 on 6/12.
Yes.
7/12, 5:25, చనిపోయాడు.
And immediately after the receipt of the injury on the head, Your Lordship, they didn't give any report. Because Your Lordship, they didn't know who bet and how it was caused. And for the first time, Your Lordship, they deposed before the court that they saw the incident and also the beating of the accused. Your Lordship,
One of thirds D. Prabhakar, Land Council for Petition and Boston Public. Next item. Item 22.
22, Your Lordship, the booklet is
Booklet, we have received booklet. Mr.
booklet.
Please collect.
They
and
are
make
not
your
collected, Your Lordship.
20th.
Yes.
At request of Land Council for appellate list on 20th. Yes. First bail application. No, first bail application dismissed. Yes. I see there is specific condition of application. Even dying declaration is also there, right?
The dying declaration, nothing is there.
Where is the dying declaration?
76 million.
Ah.
On the dying declaration, he absent stated that her husband had tried to save her. And he poured water. He will pay 77 million.
They are at 77.
Yes. ఎప్పుడు ఎలా ఎందుకు జరిగింది నిన్న సాయంత్రం ఇంట్లో ఉన్నాను
We are at 77 only.
సాయంత్రం ఇంట్లో ఉన్నాను మా ఆయన నాతో గొడవ అయింది. వేరే అబ్బాయితో మాట్లాడాను ఎందుకు మాట్లాడాను కొట్టాడు మా ఇంటి పక్కన ఖలీల్ అనే అతను ఉంటాడు మా ఆయన కూడా ఫ్రెండ్ నేను ఎందుకు మాట్లాడాను కొట్టి శిరోసం పోసి అట్లాంటి పట్టించాను నేను అరుస్తా ఉంటే వీళ్ళు పోసి మా ఆయనే తర్వాత ఏమైంది చుట్టుపక్కల వాళ్ళు అందరూ వచ్చారు నాకు ఫోన్ చేశాను నన్ను భువనగిరి హాస్పిటల్కి తీసుకువెళ్ళాను అక్కడ నాకు మందులు ఇక్కడకు రాస్తారు బయట కూడా వచ్చాను ఇంకా ఏమైనా చెప్తావా నన్ను ముందు నుంచి మనం ఆ అమ్మాయి బాగుంది ఈ అమ్మాయి బాగుందని రెచ్చగొట్టేవాడు అందుకు నేను మొత్తానికి అబ్బాయితో మాట్లాడాను ఇంకా ఏమైనా చెప్తావా అండ్ యువర్ లైఫ్ కండిషన్ మీద దేర్ ఇస్ నో హెరాస్మెంట్ ఆర్ ప్రీమెడిటేషన్ ఆర్ ఇంటెన్షన్ టు కిల్ ది వైఫ్. In fact, she has given the explanation that there was a obstruction. And he,
No, you have to read answer to question number 6.
yes,
Page 77 again.
yes, sir.
నిన్న సాయంత్రం.
నేను సాయంత్రం ఇంట్లో ఉన్నాను మా ఆయనతో గొడవ అయింది. నేను వేరే అబ్బాయితో మాట్లాడానని ఎందుకు మాట్లాడతాను కొట్టాడు మా ఇంటి పక్కన ఖలీల్ అనే అతను ఉంటాడు మా ఆయనకు కూడా ఫ్రెండ్ నేను ఎందుకు మాట్లాడాను
ఎందుకు మాట్లాడారు?
కొట్టి నిరోధం పోసి బట్ట అంటించుకొని వచ్చి నాకు అంటించాడు సంస్థ ఉంటే
Motive ఉంది. Motive is also there. Everything is there.
he wanted to return her.
Who?
The husband, the accused. If he really had the intention of killing her, he would have directly poured the kerosene on her and burned her. And also, he himself saved. That is the statement given by the victim. నేను అరుస్తా ఉంటే నీళ్లు పోసి ఆయనే
ఫస్ట్ అయితే అంటించేసింది కదా, అంటించగా లేదా? అదే
he says there was an altercation between the fathers and he wanted to threaten her and he had no intention of killing her to murder her. If that is the intention, he would not have. He herself says that he had poured the water and tried to save her and also accompanied her to the hospital. And she never said anything that there is any harassment prior to and subsequently. Whatever she says matter, he is suspecting that because she is talking to the
Khalid.
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 And also the statement of the Dr. Millard, the death, the cause of the death is Millard, is also given Millard.
Who is the doctor?
Yes, please.
Doctor is
That page
PW 18.
18. Not here. Page 21.
21.
Page 93.
Page 44 is the doctor's.
Yes. Even the doctor also stated Millard that death is due to the infectious disease.
70% of burn surface involved.
Yes.
I completed post-mortem examination. No.
That page 45 Millard.
No.
I completed the postmortem examination at 4:15 p.m. on 24/11/2015, and the deceased died in Gandhi Hospital on 24/11/2014 at 7:30 p.m. The cause of death, to the best of my knowledge and belief, was due to infected burns involving 7% of total body surface area. Exhibit 20 is the requisition issued by the hospital to conduct postmortem examination of the death body of the deceased Ramya. In the postmortem examination report,
70% burn.
examination also that it is true observed with presence of almost golden and plus appears 3 to 4 days after sustaining the injuries. You prove that it is not mentioned in exhibit P21 that the first 3 to 4 days after sustaining the injuries. I did not note down the name of this. This is the statement given by the Dr. Miller, who was examined as PW 15 Miller, PW 18 Miller, and given the report also Miller. Page
20 is requisition, 21 is the report.
21, page 93.
Yes.
Opinion as per the cause of death, page 96. The cause of death, to the best of my knowledge and belief, was died due to infectious burns involving 7% of total body surface area. Therefore, Miller, that is not instant. After 4 years of the treatment, because of this infectious disease, that is not directly to the attributed to the burn injuries.
What is the date of incident?
21,
21?
11, 2014.
21, 11. 20th P1 is. Exhibit P1 is on 20th.
Yes. And the death is on 24.
1 second. What is the date of incident? Incident is 20th.
Yes.
20th 11. Date of death?
20th. Death is 24.
4 days. Within 4.
4 days. And 3 days to what? But the first was formed due to the infection in the blood. 3 days. That is
Ultimate గా బర్న్ ఇంజురీస్ కదా వసంత్ రాయుడు గారు.
I'm not saying that treatment had it been treatment properly.
Intention to
For
kill or not,
three-
that we will consider at the time of hearing of the appeal, not now.
I'm only saying that because 10 years point where Millard is the one.
ఏం చేద్దాం? No sympathies 302.
No, I am not saying the sympathy Millard. It is the
What
person
about
Millard
precious life of the wife?
who tried to save the Millard. That is the treatment.
ఫస్ట్ అంటించిన తర్వాత సేవ్ చేస్తా అంటే ఎట్లా?
Even the dying declaration, she herself has stated.
Anyway, we are dismissing this application. Good. 3.
Your Lordship, may I have it next week, 20th. May I request your Lordship, last case, your Lordship, regard to last
paper,
case, Lordship,
20th.
20th. 20th, your Lord. With regard to last case, your Lordship, one submission, your Lordship. Absolutely, there was no motive and intention. And another thing is, your Lordship, there is only one injury on the head. Lordship, that was on the back side, the front side. But as per the
There is
prosecution
no
case,
injury on the back of the disease
Yes.
was your submission.
yes.
That we have considered.
And only one in single injury alert, single injury, there is no intention or alert is motive.
ఏం చేయాలి మీ ఫ్రెండ్ మీ పని అంతా మేము చేయాలి యూ టు డైరెక్ట్ రిజిస్ట్రీ టు సెండ్ నోటీస్ కదా మాకేం పని యాజ్ లాంగ్ యాజ్ యూఆర్ హోల్డింగ్ ఒకళ్ళ ఇట్ ఈస్ యువర్ రెస్పాన్సిబిలిటీ సో దట్ అక్యూజ్డ్ విల్ ఈజ్ ఇన్ జైల్ రైట్ అదే ఆన్ విచ్ డేట్ ఎస్ మేడం వై డోంట్ టు సర్వ్ నోటీస్ ఆన్ ది అక్యూజ్డ్ ఈజ్ ఇన్ జైల్
Yes, sir.
రైట్ శ్రీ రవి ఏం రవి ఉండే ఫుల్ నేమ్
G. Ravi.
G. Ravi, Sri G. Ravi, Land Council representing Mr. A. Prabhakar, Land Council for appellant. Already rational, no objection to the appellant and Mr. Land additional public prosecutor shall serve notice on the, where is the proof? I request of Land Assistant Public Prosecutor to file proof of service in compliance with order dated 14/22, based on 4th December.
Plus, and rate is.
ఒకళ్ళ పేషాలు నెక్స్ట్ ఇది రిక్వెస్ట్ 2 weeks time రిక్వెస్ట్ ఆఫ్ కౌన్సిల్ ఫర్ యు ఆర్ అపీరింగ్ ఫర్ దెన్ వై రఘు నేమ్ ఇస్ ప్రింటెడ్ వేర్ ఇస్ రఘు గురు హౌ మెనీ అక్యూజ్డ్ ఆర్ దే 2 accused so one accused maybe you are appearing for other accused raghu guru at request of Sri G. Ravi Land Council.
Two appeals are there. Two appeals are there. 49 and 217 of the law.
40.
Criminal appeal number 49, filed by A7, A8 and A9. And criminal appeal 217 filed by A1, A3.
217 is not there today, right? 217 is posted to which date?
So that I have to verify.
List along, none of those, sorry, at request of Sri G. Ravi Land Council representing Sri A. Prabhakar Land Council for appellants. List on so and so date along with criminal appeal number. So like offense 3
Because they never step maybe once for a counter charge. Is there? There are 3 witnesses give them hospital. The final
3 eyewitnesses. One second. Charge sheet file under 304. Charge sheet file under 304. Convicted.
Charge to pay 100.
1 second. 304.
Charge the page 100.
Page 120. Correct. Charge framed under 304. So found guilty under section 304.
And that means section but paying at 639, confirmed number case for this. No evidence. That's for this page.
All three replies to the return basket. Means one direct line. It's one to direct line.
Yes.
In fact, if there is one study did not support the case for entirely, this case they were being seen of the incident and what they keep being their others. And the disease lying on the ground. The state was the person that they informed them that the accused hit the disease. Those people not be examined, go arrested, stated that there is no evidence. The person who unless the body the accused were not examined by the state. So that is what they do the bus stand immediately after that they had taken the disease and heard others say that the accused hit the disease. Who those other persons are not stated, prosecutor did not find any witnesses. Three of them have been declared hostile with prosecution. And they said, no, believing this problems.
TWs, 1, 2, 3. 1, 2, 3 were declared as.
And some other people were not concerned.
That fact was recorded by the trial court in the judgment. It's a paragraph.
That's not finding the problem. And later in the correct
3 not.
he comes to conclusion that no evidence. And now can you see on the section 3 on? That's one of the elements which was happening there.
Date of judgment,
Kind of getting sorted.
7th December 2021.
Your the 2nd December 22.
Ah.
2nd December 22. For the grants. There actually no it is but there is only for a money connection being the proper to. So there is that damage.
That's all.
That's the nothing.
Yes, ma'am.
If your lordship, the deceased was doing his duty, your lordship. The deceased was doing his duty, he stopped him because it was late hours at 1 PM, 1 AM. He stopped him entering into the bus stand, your lordship. That's why there is no motive in this case, but due to sudden means in fit of anger, he hit.
What do you say on the legal aspect? Charge sheet
Yes.
was filed under 302 IPC. Charge was framed under 302 IPC. He was convicted under 302 IPC. What do you say on that?
Because it's a case of 304.
302?
Part 2.
I'd say.
All the practice should be evidence that all the thing was fair.
I'd say. అవును 127 217 అన్నాడు అవును రెండు కలిపి బెయిల్ ఉన్నట్టు బెయిల్ అప్లికేషన్ 18th December లిస్ట్ along with criminal appeal number 217 of 2023 18 pages.
I think very non-stop.
We are not sitting in the afternoon. We told senior also, Mr. Damodar Reddy. We have to see the special bench is there, Mr. at 2:30. This week you have to, from next week onwards, there won't be any special bench. That is the problem. And yesterday we have heard bail applications, today we are hearing bail applications, maybe tomorrow. So we will list it on 20th. Anyway, this application, appeal is of 2023, record వచ్చిందా? Record also we have not received. వచ్చిందా? Record we 20th. In it one, item 28, a request for plan council for appellant list on 20th. Yes. Yes, in.
Is that today we filed Miller to depositions and
Depositions.
just Miller taken up day after tomorrow.
Yeah. Day after tomorrow. Day after tomorrow. అప్పీల్స్ ఎప్పుడైనా లేదు దామోదర్ రెడ్డి గారు 2014 అప్పీల్స్
It's the first bail application, Miller.
They made
Yes.
14th అంటాం 14th. Give the ESR number. Might be at request of land council for appellant list on 14th. In the meanwhile, list is directed to the different put up memo filed by land council for appellant. Give the ESR number, we will. What about other matter?
Yes,
Matter which was passed over.
Yes, Miller.
You want to argue?
Yes.
We will hear you at 115, 120.
20 Miller again it will be
ఏం చేస్తాం మరి
Yes.
తప్పదు.
Miller disappear.
45 bail applications are there today. 45 or 50. 50.
Right, in this matter, Miller, it's a double matter case, but Miller, so far as the petitioner is concerned,
We'll hear you
it's
at
not,
We'll hear you at 120. There are 3 more matters, 120. Yes. Yes, Vamshi.
Please. Miller, the accused is
Paper book received.
Miller, sole accused convicted for the offence under 302, 376, my lord.
Age of the victim?
Both are Miller, 19 years insofar as victim and 21 years is the age of the accused.
We are not asking the age of the accused. We are asking the age of the victim.
Lord, that is why I am submitting like it's a consenting and it was, yes, my lord. As per the contents of the complaint case of the prosecution itself, it's law of a my lord, and my lord,
He was convicted for the offences?
302 for life, my lord, under 376, my lord, for 10 years and
366?
my lord, 7 years. Record is mostly on basing on the, well, it's a linking of events is the issue, my lord, circumstantial evidence, based on circumstantial evidence, the, my lord, the conviction is imposed on. And the linking of events is totally based upon, my lord, the vehicle being tracked by CCTV footages. My lord, the incident happened on 27/11, my lord, wherein the issue was, my lord, the date of it was the birthday of the deceased. She informed at her residence that she is going to meet the accused herein. And thereafter, after meeting, my lord, at around 2 o'clock onwards, and after at 6 o'clock, her phone got switched off, and her body was traced at 9:30 in the night, my lord. That is the case, my lord, on hand. My lord, before, my lord, I submit.
It's a consent.
It's a consensual more so, my lord, if your lordship may take for a moment one photograph.
302.
302, my lord. My lord, initially my lord, investigated for 376, my lord. 302 is, my lord, based upon the medical, but an head injury was, no, my lord, bleeding took place from there. If your lordship sees for a moment 180.
PW 25.
FSL.
Doctor conducted autopsy.
Yes, my lord.
Let us go to his evidence first. PW 25.
25 is FSL report, my lord.
PW 25. Doctor who conducted autopsy. Not one. There are 7 injuries.
My lord, assistant professor in Department of Forensic.
There are 7 injuries.
My lord, that is with regarding if your lordship sees the nature of injuries is what they state. Left palm, right palm, that optical lobe.
The cause of the death
My
according
lord, that is what is, my lord, the bleeding from the head, my lord.
I gave my final opinion that the cause of death was due to P42 is the PME report, right?
42, my lord, PMA report.
Yes.
Page 257, my lord.
Page
257 is PMA report, my lord.
257.
But before that, my lord, I only draw one my lord, kind consideration of the court, my lord, page 183.
What is 183?
The photograph, my lord, of the deceased. Well, inference, well, what I'm respectfully submitting, it is not case where as projected by the prosecution, my lord. From what it appears. More so, my lord, the nature in which, my lord, it has been happened. More particularly, I would like to read the evidence of PW6, which will go to the version of the prosecution, my lord. That is basing upon the extrajudicial confession. PW6 is, that's the sole PW6 and PW12, my lord. These two persons' evidence is, and then the my lord, linking of, is the friend of the accused, my lord. It's an extrajudicial confession which has been taken into consideration for convicting the accused, my lord. My lord, page 38 for a moment, my lord. Yes, my lord. My lord, my lord, on 27/11/2019, I along with LW9, we are going on the bike on LW1 for giving it for service at Mulgod Road, Warangal. At about 3:30 p.m., when we reached Vidyajyoti Degree College, the accused called me and informed me, Ma Ammai is affected with aphasia and asked me to come immediately to Rampur. I told him that we are going to Warangal for giving bike to service and told him that to go to hospital. The accused called me continuously 3 to 4 times. When I called back again, he asked me to come immediately. When we reached the Indian Oil petrol bunk after crossing we saw the car, the accused beside the road near the petrol bunk. On going near the car, we saw one unknown woman sitting in the seat beside the driver's seat. She was lying unconsciously and her eyes and mouth were open. There were blood stains on her dress and on the seat in which she was sitting. When I asked who she was, he said that she was his lover and that it was her birthday, and so he brought her. He further told me that he did so and so with her thought. She did not consent and that she screamed, and thereafter she did not talk. He asked our help to take her to the hospital. We were frightened and advised him to take her to hospital with the help of his parents, and we returned to the showroom in Warangal. On the next day morning, I read the newspaper that the accused Soyans. Then, my lord, PW12, my lord, the efforts, my lord, and the panic situation.
Who is PW12?
My lord, he was the person who was, my lord, identified the accused, saying that, my lord, accused, my lord, requested him to open the railway gate so as to take the, my lord, the victim to the, my lord, for treatment as she was not doing well. My lord, only to show his, to that extent of his acts, my lord, with regard.
There is not in dispute.
My lord, not in dispute, my lord.
Death is not in dispute.
Death
Death is not in
not in
dispute.
dispute.
On that particular day, birthday of the deceased
Yes,
is not.
but is also not in dispute.
What is the defense you have taken during trial?
My lord, that is what, my lord, I submit. There are, my lord, as per the prosecution, my lord, they have stated with respect to the relationship between the petitioner and the deceased, and with regarding to, my lord, my lord, the incident which has happened, though it is circumstantial and they were not having knowledge about it, but on hearsay they have stated that this might have caused death is due to
Prosecution version.
yes, my lord.
What is the defense you have taken?
My lord,
She is your lover.
my lord,
You have taken her out on the day of on her
yes,
birthday.
my lord, that is what I am submitting, my lord. My lord, there was an attempt made by the defense. To be very honest, my lord, the counts, my lord, the
Your
counterpart to go for an acquittal by my lord not placing the entire incident before the court, basing upon the lacunas of the prosecution. My lord, I fail is concede that, my lord, that basing on the lacunas of the prosecution, he tried to, my lord, make a case. It is a case for acquittal. But in fact, if you would have gone with the, my lord, the true version, my lord, the conviction wouldn't have been on those two counts, my lord.
What is the true version according to you?
My lord, if the version of prosecution and the true version is taken to a note, it is more probable.
What is the true version?
Yes, my lord. They went out, my lord. They are majors. There is no disputing about the age. My lord, they consented for, my lord, having, my lord. Well, during that process, she started bleeding and she fell unconscious. He was panicked. He, my lord, immediately at 3:30, because they left at 2 o'clock from the residence of the complainant, the victim to meet the accused went at 2 o'clock outside your house, and thereafter they met
and they went out and purchased puffs on their travel, my lord, while they were traveling. That is also recorded. They purchased some bakery items for consumption, and thereafter, my lord, while this my lord, they consented for this particular act with their own interest. While that process, my lord, she started bleeding and fell unconscious. My lord, after she becoming unconscious, he tried to contact his friend to take her to the hospital. My lord, later on, since they denied, he attempted to take the hospital. The next attempt.
What is the date and time of that particular incident according to you?
My lord, this happened at 3:30 to 4 o'clock.
3:30 to 4 o'clock. What is the time of death?
That is not stated, my lord.
No, we are asking you.
My lord, he is also on the way. My lord, the episode of 2000, my lord, that is what, my lord. PW12.
After incident, what is that he has to do?
Yes, my lord, that is what I am stating, my lord. The evidence to that effect is PW6 and 12. PW12, my lord, while he was, after friend's denial, my lord, he made an attempt to take to the hospital or to the parents. So, yes. But the delay caused by the PW12 while opening the gate, that is also there, my lord.
Opening railway gate.
Yes, my lord.
What is the delay?
My lord.
1 minute.
No, my lord. Not 1 minute.
15 minutes?
No, my lord. 15 minutes, what he says.
15 minutes.
Yes, my lord.
Who is the PW12?
Gate man, my lord. There were two trains which were passing and it was automated gate and he has to take his superior, my lord, other superior.
He will go with you. So within 15 minutes, everything is over.
No, my lord. Prior to that only, your lordships have stated that he has informed to his friends that to come and help him out to take her to the hospital. My lord, after they coming and meeting and denying, then he took her, he was taking her to the hospital. Thereafter, my lord, since she lost her conscience, he was totally panicked. He doesn't know what to do, and he left the body near the 1 kilometer away from the residence of the de facto complainant and then left.
Dismissing this application. Mr.
I understand, my lord, but only thing what I submit is, my lord, what my respectful submission is, my lord, under 2 counts. My lord, it cannot be taken as 376, not 302, my lord.
We consider while hearing the appeal, not now, while considering the bail. Heard Sri P. Vamshidhar. Heard Sri P. Vamshidhar.
Past 4 years.
3rd March 2024.
Deeply obliged.
None of this.
Records are not, I'm asked to take time in this.
When do you want?
On 20th, my lord, your lord.
20th equipment.
Any,
At request of land council for appellant list on 4th December. Yes.
May please, your lordships, the
What is IA3? What is IA4, madam?
one is for
Suspension, the other is for bail. Why you are filing two of them?
the appellant's was asked by the appellant's wife is blind, your
Paper
lordships.
book we have not received.
Yeah, but the
You have filed depositions.
no, but your lordship, she's blind. Find a blind certificate. The appellant's wife, your lordship.
Excuse,
The appellant, the accused wife, your lordship.
appellant wife. What is the offense 302?
Offense 302, your lordship, extrajudicial confession, your lordship. There is no eyewitness, your lordship. In the construction work was going on, your lordship, and he in the campfire, he went into the campfire,
Who?
and the accused and one another person who was deceased, your lordship. Both were there. Then he
Why you are referring the disability of the wife? When the offense is 302, where are the sympathy?
because there's no live, nobody to look after.
అది ఎప్పుడు తెలియాలి ముందు అఫెన్స్ కమిట్ చేసేటప్పుడు ఉండాలి మరి కన్ఫెషన్ కమ్ రికవరీ పంచనామా ఇస్ P8.
Right. There's an extrajudicial confession. Your Honor.
Confession report.
There is no direct connection.
Anyway, record we have not received, depositions we have not filed.
There's no direct.
Just after some time. List on 4th December. In the meanwhile, the ST shall call for the record from court below. Prepared for public put up. Yes.
Much appreciated.
Yes, Mr.
Next. Here the appellant has been convicted for offence under 302 and 201, your lordship. Where in this case A2 was acquitted for offence 201, read with 34. This is the case of the prosecution that only on circumstantial evidence he has been convicted, your lordship.
There is no eyewitness.
There is no eyewitness in this. The brief facts of the case of the prosecution is that the deceased, there are classmates,
Who deceased and accused?
deceased and accused.
What is the motive then?
So deceased state that he want a cell phone. Stated that
Who deceased?
deceased. So they paid 8,000 rupees to the other person, JCL. JCL, your lordship. Junaid, who is not in this. So he received 8,000 stating that he had a shop and online they will get a cheaper rate. And then they had some dispute with this amount. It seems that he is requesting to give back the amount, they could not give it. And that is the motto, and because of that, he has killed.
So entire case is on circumstantial evidence.
Yes, your lordship.
Please come to page 205. Point number 124, the circumstances explained by the court.
Yes, your lordship. The first circumstance is the case of the prosecution.
So they are
Two.
quarrel. So this is not in dispute. First circumstance.
This is under 313. He admitted that only I slapped.
No, quarrel with regard to this particular incident is not in dispute, right? First circumstance.
The only
not in
evidence
dispute.
before the court is lordship that the accused A1 under 313 examination. He stated I only slapped the deceased. The rest of the thing he declined. He told I slapped him.
Even first circumstance, that is quarrel also you are disputing.
That is the only thing. He only slapped him. That is
So
admitted.
quarrel you are admitting.
Slapped. He said
At least to the extent.
extent.
Second-
Based on that only conviction is there.
Second circumstance.
A second
Deceased
circumstance.
left home on 24 to 2019 on a phone call received from accused number 1.
This aspect has been not proved by the prosecution, your lordship.
You are also denying.
Yes, your lordship.
Then
Because
third circumstance,
no, there was no phone call. Simply PW123 stated that
third circumstance, deceased was last seen in the company of,
yes,
which witness spoke about this fact?
PW6, your lordship.
Who is he?
He is also stating to be classmate of this deceased and the PW is accused.
So he, that was on the day of incident, right?
Last time that when he slapped, he stated I was present there.
Right. So maybe for quarrel, he is an eyewitness. For
But-
quarrel at least.
But what he stated, Your Lordship, in his chief, that I have received a call from unknown number.
Next, fourth circumstance. Dead body of the deceased was discovered at the instance of accused number one.
This the
What
court
is
has, court has not accepted this, stated that as per the IO investigation and report, it is not proved.
Who is IO? PW?
PW 11. It is not proved.
Then fifth one. Death of the deceased.
Some injury was there on his neck. So here, Your Lordship, I submit that the PW 123, who has to be the father, mother, and sister, they all stated that the incident happened on 24th. They received a call, and his son went on a scooty to meet the accused number one.
They have not collected call data.
Call data has not been filed. No CDR has been filed. And
CD file.
Call-
Please exhibit P5 then.
CDR is not filed, Your Lordship.
CDR registration.
CD, that is, Your Lordship. There is CD that also at the time of trial, whatever the submitted along the charge sheet, that was blank. Then again, that is disputed without giving under against the 207 of CRPC. That is strongly connected by the counterpart, Your Lordship. So my submission here, Your Lordship, when the PW 123 states that on 24th he waited, 25th they lost the complaint at 2:45, and then the same night police brought them to the police station, and in the same night they have recovered the body. So then this punch witness and
Who is the puncher for the recovery of the body?
that is the VRO and others, they stated that
PW?
PW,
No, witness to the confession statement of A1.
that is the VRO and
Here who is PW?
permanent, Your Lordship. PW 8 and PW 9, Your Lordship. 70. Seventy-eight, Your Lordship, sorry. 78, page number 78.
PW?
PW 10.
Hero Dingesh, right?
Yes, Your Lordship.
Yeah.
Where they stated that they received a phone call on 26th, 10:30.
Yes.
So they went there at 10:30 గంటలకు అక్కడికి సిఐ గారు ఇంకా ఇద్దరు ముగ్గురు పోలీసు వారు ఉన్నారు. వాళ్ళు గౌతమ్, శివ అనే ఇద్దరు ముగ్గురు పోలీసు వారు ఉన్నారు సార్.
ఎంజాయ్ చేస్తాం వచ్చేసి
In the cross examination, it was elicited, Your Lordship. They have stated that up to 2 they were in the police station. That is the cross examination, Your Lordship. Whereas the PW 123 says that in the night only they have confessed. So if that statement is taken true, then this will become false, Your Lordship. So court has not believed this version. They stated that PW 123 categorically stated the body was recovered and photographs, everything says that. So the punch witnesses and this IO report is not accepted. Based on only this PW 123 conviction was granted, Your Lordship. My humble submission, because lot of contradictions are there. And one, the PW3, the sister says that first we only gave the complaint of missing. And subsequently we stated to the police we have doubt on the A1. So then the police has custodial interrogation on the same day. So my humble submission is serious doubts on the story of the prosecution, Lordship, and because there's no eyewitness and this chain is incomplete, Your Lordship. Even for eyewitnesses, that amount has no witnesses there. So my humble submission may be advised.
This is circumstantial evidence, Your Lordship. Motive is there, last seen witness PW6 is there.
What is the motive?
Motive was there, which is explained in this first circumstances, Your Lordship. The prosecution case is that motive for the murder was quarrel between deceased and accused number 1.
For 8,000 rupees.
Yes, Your Lordship. Second is last thing is there, Your Lordship, PW6. Third thing is that body was recovered on at the instance of the accused, Your Lordship. Because he was with the deceased and it is in the sole knowledge of the accused, that's why body was recovered.
Yes, sir.
That's all.
May I please, Lordship.
Record we have not received, number 1. Number 2, did you file depositions?
I filed depositions, my lord. Appellant. Appellant is the wife.
Madam, ready?
And appellant is the wife, my lord. Deceased is the husband.
Appellant?
No, the appellant is the wife is the appellant, my lord. The,
If he is the appellant.
yes, ma'am.
Deceased is husband. Reverse case. There. What is
But there are no eyewitnesses, even as per LW1, PW1. Not she saw the appellant taking her 2 children, PW1, my lord. Deceased is the maternal uncle of LW1, PW1. And the marriage is a love marriage between the deceased and the appellant.
ఎందుకైంది the incident? Law marriage.
Because because he was addicted to drunken, my lord. He was even as per the report.
So addicted to alcohol.
Alcohol. Not even as per defense taken by them, she never killed the husband. He was in a drunken stage on that day. Even on that day, they went to police station. There was a report given by the appellant to the police, even as per the version of PW1. And they have cautioned him, and they begged, police have begged the deceased. That is the version of the PW1. Lordship can see page 54, PW1. Evidence.
Motive అది కాదు. He has started harassing her, suspecting her fidelity.
Fidelity.
అది కదా motive. చెప్పకుండా అన్ని చెప్తారు.
No, that is there, Manoj. That is one of the version. Now, before that, Manoj, your Lordship kind appreciate. Even as per there is no Lazarus. The death is due to the cardiac arrest and because of the brain injury of the brain.
Second, who is the doctor who conducted?
PW8. PW8,
Where is the evidence?
page 68.
68.
Fracture occipital bone with
Death, to the best of my knowledge, was cardiorespiratory arrest due to head injury. చెప్పారు మరి.
yes, man, due to head injury.
నేను కొన్ని రోజులు లోపల ఉంది.
Because she is having 2 children, not now.
No,
You
sir,
only-
in 302. మార్నింగ్ నుంచి చెప్తాను అందరికి.
Any date, so
Item 100.
Record we have not received.
Milord, in this, your lordship already granted a bail to 3 and 4, Milord. 3 and 4, your lordship already granted a bail, and I filed for the 1 and 2, Milord.
Petition is 1 and 2.
Yes, Milord.
Where is the order?
Yes, Milord, I already have given,
Where is the order?
already last second date of hearing already. Sorry, one minute.
So they filed a separate appeal, right? 95 of.
That was 95, criminal appeal 95, it is 195, Milord. Your lordship,
Just trial court convicted petitioners of the apparent 3 and 4 on the ground that in the face of the evidence, it has to reveal that appeal can be deceased. In furtherance of their comment, in the said finding is counter to the list. No, 3 and 4 are suffering with paralysis, Mr.
only 3, my lordship.
And in proof of the same, she has filed medical.
Not both accused, Milord, 3 and 4, only 3, Milord.
No,
Yes, lordship, only 4 who is suffering with paralysis, 3 was granted by your lordship.
no, we have recorded that both of them are suffering with accused number 4 is suffering.
Only 4 is suffering, lordship.
Yes, madam. What do you say? According to him, 1 and 2 are also standing on the very same footing. What do you say? Is there any specific overtake? Where are the depositions?
Milord,
Depositions you have not filed.
Milord, my submission, your lordship, while passing this order, lordship mentioned that there is no separate allegation on 1 and 2. It's a both.
No, second, we have referred paragraph number 25 of the impugned judgment.
Yes.
is 1.
Yes, Milord.
Number 2, A4 is suffering with paralysis.
Yes, Milord.
So on those 2 grounds, we have granted bail.
Yes, Milord.
What is your submission now?
My submission is there is no specific allegation against even 1 and 2
You
also.
have copies of depositions. Why don't you file depositions?
Any short at me, I'll file deposition.
File if you have depositions. Is there any specific overtake against A1 and A2?
A1 and A2, because your lordship, this last scene is there, A2 came to the house of the deceased and she took along, she took deceased along with her to the house.
1 second, read paragraph number 25 of the deceased.
25 of the judgment.
Paragraph number 25 of the impugned judgment.
But it is noted that none of the witnesses saw the accused number 1 to 4 attacking the deceased. Because the attack in the house, your lordship, A2 came to the house of the deceased. She took deceased to her house, saying that her husband is beating her. So to save the accused number two, a deceased went to the house of the A2, your lordship, and A1 and A2 attacked in the house. So that's why nobody noticed the incident.
On what basis conviction was recorded then?
Last scene is there, your lordship.
Who is the witness?
The complaint, actually, there is no proper.
Is there on para 14, your lordship of the judgment.
Deceased along with his wife, PW1, mother Kamalamma, brother so and so, was in the house. Secondly, accused number two came to the house and asked the deceased to accompany her to the house of accused number
Accused
one.
number one. Thirdly,
Thirdly, so and brother of so and so were woken up by so and so. We informed them that accused number 1 to 4 were beating the deceased in the hut of accused number 1. Which witness informed?
PW4.
PW,
3 to 4 years.
with your permission, lordship, kindly page number 8 of the impugned judgment, my lord. Page number 8. The first para itself, my lord. The prosecution has failed to establish that the house where the deceased was found. Page number 8 of the impugned judgment, my lord. The prosecution has failed to establish that the
Reading.
but the first para itself, yes, my lord. The prosecution has failed to establish that the house where,
This is the contention of the accused
yes, sir.
before the trial court. Why you are reading this?
My
You
lord,
have
why
to
I'm
read the
submitting,
finding.
why I'm submitting, my lord, they were not filed any document relating that the house which belongs to the accused, my lord.
If you have depositions, please file. Otherwise, we will.
I
call for
have
the-
deposition with me.
File it.
Yes, my lord, I'll file, my lord.
Where are the depositions? You have not filed, right?
I'll file it, my lord.
File it.
Here, yeah, any short it may be given.
14th,
I deeply oblige.
at request of Sri Sushil Kumar Pandey. Yes. Other appeal is posted to which date? 95?
It is December, my lord.
Anyway, we will list it on 14th. We'll see on 14th.
Yes, my lord, yes, my lord.
Hmm.
Deeply obliged, lord, sir. it was 31st, 10 it was posted, lord, sir.
95, along with Anila. Yes. Yes, Mr. Narsma.
Elections. The appeal, the appellant is the accused number 6, your lordships, where there is no any motto, your lordship, the offence is a 304.
Because we have not received, you have not
Not-
filed depositions.
Depositions
That's
not-
yours. If you want to file depositions, file it. Or else
There
we'll
is
call.
no eyewitness, your lordship, there is no eyewitness.
On what basis conviction was?
Only
filed?
conviction, only dying declaration, your lordships.
File dying declaration. We will see that. అది వేయాలి కదా minimum. Even relying on dying declaration, trial court can convict. Yes or no? Exhibit P18, you have to file dying declaration.
Yes, yes, is there, your lordship.
File exhibit P18, sir. When do you want, 14th or 17th, 16th? ఎప్పుడే సార్ ఉంటే వేయండి లేదా అదర్వైజ్ వీల్ కాల్ ఫర్ ద రికార్డ్ వి విల్ లిస్ట్ ఇట్ ఆన్ 4. ఏం చేస్తారు ఇట్లా ఎక్స్పర్ట్ చెప్పాలి కదా.
Not having dying declaration.
List on 4th December. In the meanwhile, list is call for the record from
Sorry,
board
sorry.
below, prepare paper book and put.
Dying declaration is there, your lordship.
మరి వేయాలి కదా ఏంటి 14 పెట్టేస్తాం.
I think so, it is there, I think so.
వేసినారా ఫైల్లో? మీరు ప్రిపేర్ కానట్టు అనిపిస్తుంది మాకైతే.
No, no, you'll have.
మరి ఇటు దిక్కు ఎట్లా అండి? వేర్ ఈస్ ఎగ్జిబిట్ P18 డైయింగ్ డిక్లరేషన్?
Day after tomorrow, I will file.
Day after tomorrow, 14th. At request of at request of Land Council for Appellant to file copy of exhibit P18 dying declaration list on 14th. P18. P18. 18, right.
Items additional in the
అదే అడిగిందా నేను ఇక్కడ గురించి వచ్చినాయి అని తెప్పించాలి కదా 16-17 నుంచి
Negligible.
5 years ago 3-4 times మన డైరెక్షన్ టు ద కాలేజ్.
Negligible.
So you have filed depositions.
Yes, Lord. It's a case of circumstantial evidence.
Sole accused.
Not sole
It's
accused.
a A1.
He is A1. 12 accused were tried for the offense, various offences, including 302. And all of them were acquitted
The
and
record we have received 3 volumes.
Record is ready, consists of 5 volumes.
5 volumes. 5 volumes are with us.
record is ready.
Ready. We have received even PP also.
Lord, if I have not received it.
Collect it.
All right. 20th year.
At request of Sri P. Prabhakar, the land council for appellant, is on 20th. Yes.
Senior counsel in the hybrid mode. Senior counsel Pradyumna Kumar is hybrid mode.
Yes, senior. Record వచ్చింది. You can collect record.
Yes, madam. Yes, madam. And the last
Yes, Mr.
occasion,
Pradyumna Kumar.
and the last occasion, senior counsel argued the
I
matter.
argued the case. But in fact, I have argued the case last occasion, but there are no eyewitnesses to the occurrence. This case is of circumstantial evidence, my lord.
Yes, madam. Yes. We have heard him last time. You have to argue. 302. Prepared or not prepared? Day after tomorrow. Tomorrow is a dedicated final hearing. Appeal, you know,
I'll do it.
at request of land assistant public prosecutor, listed day after tomorrow.
Obliged.
Obliged.
Yes, Mr.
May I please your lordship, like to represent Mr. Nitendra Singh, my lord.
Record you are not received.
Bail application is filed on which depositions are also filed.
Filed up. If you are ready, we will hear. We don't want record.
Ready.
Yes, madam. Prepared or not prepared?
I'll do it.
Sir?
I'm not having it by.
Very good.
I'm having it.
Very good. So prepared. You have bundled and you are prepared. Very good.
The appellant before your lordship is accused number 1, my lord. Convicted under section 302, read with 34 IPC, sentenced to imprisonment for life. Charge sheet was laid against A1, A2 and A3. A2 and A3 were absconding, my lord.
A2.
A2 and A3 were absconding. Therefore, the case against A1 was separated. A1 was tried separately and convicted.
SC 17 of 25.
Yes, ma'am.
What is the allegation?
The allegation is that, my lord, there are prior disputes between the accused and the deceased person.
What are the disputes?
My lord, another criminal case was registered, my lord, between the parties in the year 2012, my lord, about 6 months prior to the date of incident.
The allegation, at least in the earlier case.
In the earlier case, my lord, they have fought with each other, my lord. 324 IPC.
320. What happened to that criminal case?
My lord, I have to take instructions, my lord. It is pending trial, my lord, as per the charge sheet at that time.
So anyway, there are disputes between the accused as well as the deceased.
My lord, the case of the prosecution is that, my lord,
Any eyewitness?
yes, my lord, PW 4 and 5 are the eyewitnesses to the case. May I request your lordship to kindly see the eyewitness, my lord, PW 4 and page number 25.
25.
Yes, my lord, of the bail application.
Page 20.
PW 4 is by name P. Jailu. I know PWs 1 to 3, LWs 1. So I know deceased Chandrayan A1 to A3. At about 7 years back, myself and deceased LW7 went to load cotton crop in lorry. After loading in lorry, we returned to our houses. I and LW7 going first and deceased coming our backside. When we reached that basement, A1 came and beat with cart peg on Chandraya's head. Then he fell down on the ground. A2 took a stone and thrown the same on Chandraya. A3 kicked his legs to Chandraya and went away. After that, PW1, LW1, LW2, PW2 came there. They shifted Chandraya in auto to so-and-so hospital. From there, they shifted Chandraya to Hyderabad. On next day, I came to Chandraya died in hospital. Accused having previous grudges on Chandraya and the case was registered against Chandraya. Keeping the same in mind, they beat Chandraya. Police examined me. Cross-examination. We 15 persons loaded the cotton in a lorry at Hanuman temple of our village. Distance between Hanuman temple and Chakali Anjaya house is about 100 meters. After loading the cotton in a lorry, it was dark night and we went to our respective houses.
The incident took place at a road leading from east to west. My house is situated 4 houses after scene of this. My house and basement house is about 50 yards. I have to go on main road from temple to my house. It is not true to say that I have to go. I have no go through scene of place to my house. A1 house is situated in different road leads from north to south. There are 20 houses situated at the basement. There are 3 or 4 houses after A1's house, the scene of place situated. There is a 3 or 4 yards distance from us to Chandriya. The Lordship may note this matter from it. When we were front, we have not seen the accused. It was dark. After hearing the sound of Chandriya, we reached there. By the time accused beating said Chandriya and were going. By the time PW1, LW2, PW2 heard the
Eyewitness is then.
Yes, my lord.
He is eyewitness. By
Yes, my
that
lord.
time, accused beating the said Chandraya and were going.
Going, my lord.
By the time PW1, LW1, PW heard the noise,
Yes.
they came here there.
From the place of incident to PW1's house is 100 meters. By the time PW1, LW2, PW2 came there, there were already 15 persons gathered there. They are neighbors. The Lordship may note this. Now, the Lordship may see the statement of the next eyewitness.
So they have not examined any neighbor.
No, my lord. Only 2 eyewitnesses.
They have not examined any neighbor.
No, my lord.
Who is PW2 next week?
PW5, my lord, is another eyewitness who accompanied the deceased and PW4 while they were walking. The chief examination is on the same lines. In the cross examination, may I request your lordship to see page number 28. Fourth line from the top, my lord. Myself and PW4 were going together. After hearing the sound, we went to the place of incident. By the time I reached the place of incident, 15 persons were present. This is contrary to the evidence of PW4, my lord. To the extent, my lord, PW1, LW2 and PW2 were not present. But that is one aspect, my lord. Then your lordship may see, apart from this, my lord, the names of these 2 witnesses are not named in the FIR. At the earliest point of time, they are not said that PW4 and 5 are the eyewitnesses. Your lordship may kindly see the FIR, page number 8. Page number 8 is the FIR. The FIR is against A1 and A2 alone.
There is not an encyclopedia.
The reason why, my lord, I am making this submission is that, my lord, at the earliest point of time, my lord, the complainant PW1 did not know who committed the offence, my lord. He has suspected A1 and A2 because of prior disputes. He has admitted in his cross examination that on the day of incident itself, I have gone to police station, but he has not given a report. On the next day, he has given a report, my lord. If at all, PW1 is the son, my lord, son of the deceased. May I request your lordship to just kindly see, my lord, the evidence of it.
That is at page 13.
Yes, my lord.
He is the son, right?
He is the son. Lordship may see the complaint.
సాయంత్రం దాదాపు 7:30 గంటలు సాయంత్రం
సాయంత్రం మా నాన్న పంచలంగా చంద్ర సంగం సురేంద్ర గారు మా గ్రామంలో చాకరి అంజయ్య గారి యొక్క పత్తి తోట నింపి ఇంటికి వస్తుండగా మార్గ మధ్యంలో ఉప్పనపల్లి బాబాయ్ బడ్జెట్ దగ్గరికి రాగానే మా గ్రామానికి చెందిన పోచయ్య హూ ఇస్ A1 A2
deceased died on the spot or
died on the spot.
No, no. మా బంధువు మల్లేశం ఆటో తీసుకొని జోగిపేట ఆసుపత్రికి తీసుకొని వెళ్ళుచుండగా మార్గ మధ్యంలో 108 అంబులెన్స్ వచ్చింది. దెన్
No, no, he has died subsequently. Subsequently, he has died in Gandhi Hospital. I'm sorry.
Conducted
Treatment.
అక్కడ చికిత్స పొందుతూ 24/3 24th
24th.
One day after the incident.
One day after the incident, he has died.
So he has lodged a complaint on 24/3 itself.
Then your lordship may see page number 18.
24th at 10:30 morning.
The lordship may see incident occurred at 7:30 p.m. on 23/3/2030.
Correct.
He has died on the next day, my lord. Your lordship may see the cross examination of PW1, my lord, page number 18.
Page number 18.
Cross examination. We reached at 8:30 p.m. to Jogipet Hospital, where my father was treated for half an hour. Police did not come to Jogipet Government Hospital. There is a police station near Jogipet Government Hospital. Circle Inspector of Police also there near Jogipet Government Hospital. On the date of incident, either ourselves or our village people did not inform about the incident to PS Aladur. On the next day morning at 9 a.m., circle inspector and police came to Gandhi Hospital. We narrated the incident to police. Therefore, my submission is that had the eyewitnesses really been there, had the eyewitnesses really seen the incident, they would have informed PW1 or the police, my lord, that so and so persons.
According to them, both of them were planted witnesses.
Yes, my lord. Basing on the prior grudges, my lord, they have suspected A1 and A2 to have committed the offense. And if at all they had knowledge, my lord, that A1 and A2 committed the offense, immediately they would have informed the police even prior to the death of the deceased that an incident has occurred. They have waited till he has died, my lord, and on suspicion, my lord, they have implicated the petitions.
They have not, doctor is PW11. I think police.
3 injuries, my lord. Fourth is a fact.
Who is the IVO?
IO, my lord, Lordship, I can see PW12, page number 40.
PW?
12 at page number 40. No,
You have to read cross exam.
yes, page number 44, my lord, second portion of the cross examination, my lord. As per complaint and inquest report, the accused are alleged to have attacked the deceased with an axe and granite stone. It is true MO4 is commonly available. It is not true to suggest that LWs 1 to 3 came to the scene of offence after the incident occurred. It is true that PW1 did not state before me and also in his complaint that LW6 went and informed him that accused were beating and trying to kill his father. Lordship may note this, it is true that PW1 did not state before me and also in his complaint that PW4 and 5 were walking along with his father behind the house of A1 when the accused attacked his father. It is true PW2 did not state before me that A1 rotated cart peg in his hand and warned them. It is not true to suggest I have not recorded the statements of so and so persons. It is true that in exhibit P1 complaint, the name of A3 is not stated. The name of A3 was stated before me, section 161 statement of PW1. I have not filed FIR and charge sheet in crime number 24 of 12 on the file of all other cases. One further submission, the son of the petitioner is a cancer patient. I have filed medical certificates to that effect.
Filed?
Medical certificates.
Medical certificate filed.
Yes. Number of certificates have been filed from page number 45.
Yes, madam.
Apart from PW4 and 5, PW2 is also an eyewitness here.
PW?
2. Page number 21. This is Chandra, junior paternal uncle.
No, 1 second. Please come to page 42. Cross examination of investigating officer.
The distance between.
No, 1 second. 10th line from the top. It is true that as per my investigation, PW4 and PW5 are the eyewitnesses to the incident. It is true that their names are not mentioned in exhibit P1 complaint and 161 statement. Where is the deposition of PW2?
PW page number 21.
What is his name?
His name is Srifella. P. Srifella.
Seychelles.
This is Chandra, my junior paternal uncle. PW1 is my cousin.
No, he only shifted the deceased in an auto, right?
Yes, your lordship. And he, according to him also, your lordship, the wife of the deceased also an eyewitness, but she has given up. The next thing, he clearly explained what had happened, who attacked, how A1 8 attacked the deceased. And one more thing, your lordship, in the cross examination of page number 22. Why the neighbors are not examined, the reason, why the neighbors are not examined, the reason for not examining the neighbors. Babaya basement situated in a street. I cannot say which side of the basement Babaya, which direction the incident took place. A1 house is situated after 4 or 5 houses of the main road. A1 is house is situated other side, the road of one Babaya basement situated in the another side. Because at the front side of the scene of offense, A1's house was situated. After Babaya basement turns which leads to our house, my house is situated about 2 furlongs away from the Babaya basement. There are 50 houses situated in between my house and Babaya basement. 15 minutes after hearing the sounds from the Babaya basement, I started to the place of the incident from my house. I reached within 2 minutes. Along with PW1 and PW2 together went to the place of incident. When we went to the scene of offense, nobody was there. 4 and 5 houses surrounded the Babaya basement. By the time I reached the place of incident, the deceased Chandra was with bleeding injuries. I went to government hospital, also Gandhi hospital. I never accompanied with the PW1 in lodging complaint at the PS Aldur. My statements were recorded to Gandhi hospital by police. But I did not know his designation. It is not true to suggest that A1 not bid to Chandraya with Carpet and that I did not went to.
Now, why the investigating officer has not examined the neighbors?
Because your lordship, the scene of offense, the residence of A1 is there at the scene of offense only. Front side of the scene of offense, A1's house is there. So nobody came forward to give the evidence in this. And even AW2, a wife of the deceased, also an eyewitness, but she is given up. So no neighbors come forward to give the evidence.
Yes. Yes, Mr. Chief. Any reply?
No.
Thanks. One of them. C. Sharon Reddy, Land Council representing Mr. P. Nitendra Singh, Land Council representing Public Protection Program and Land Assistant Public Prosecutor.
Application for
Ah.
pending application of report and notice to be conducted according to the by entering trespassing into the house of the deceased, causing their death, and thereafter nothing the death of the silver and gold ornaments. The conviction is based on its solid circumstance and recovery of gold ornaments and instead of
Who is the punch witness?
punch witness is
PW? Vishwanath Ramchandar, punch for confession and recovery.
The recovery identity of the ornaments has not been used or reasonable without steps. No test identification properly has been made as per the verified of the fatal use of matters. Apart from that, the PW1 is the son of the deceased, who has identified the jewels and taken the custody of the jewels. But in the previous report that is expected done, he says that because his parents are living separately, he does not know what are the ornaments he accused of. This is done in possession. Lodges may kindly turn to page 40.
First to come to page 30. We'll read deposition of PW10. He is VR, right? Senior executive. Worked as VR role, so and so.
Take it paragraph. On 17/8/2016, while I was on field work with the caused me of my phone at about 9:30. And instructed me to go to toy shop situated in the outskirts of Amarsagar village. I reached there by 11:30 a.m. After 10 minutes, LW40 also came. By the time I reached the toy shop, accused was found in police custody in the town. CIF police, LW19. Saishwar Gaur requested me to inquire with it. On my inquiry, accused in the presence of myself and the LW40, request to the commission chairman to the second and during night of 12/30 August 2016, and committed theft of ornaments which were in person and possession of T1 along with cash of about 29,000 in coins worth rupees 3,400, and that they are concealed in this house at Satyarama building, exit 17 is the relevant motion of confession of the accused. Thereafter, property and police to his house and shown as the gold ornaments, cash and pawn. Police see 10-1 Police also sees it in
It's a double murder case.
pepper, bloodstained cloth and band of record. Number 25 is the signal, 26 is the pepper, number 27 is the bloodstained shirt, and number 28 is the bloodstained pant under the cover of search and it's a check. 8 is the relevant of search and search. It's true, I am a government employee. It's not with suggest the government employee cannot be shown as witness in the cases. Police had Panchrama in the presence of myself and I held everything to HR and thereafter police signed the judgment. I signed the Tory shop in level and at the time of seizure on P7 and P8 are 2.5 pages. I know the contents of P7 and P8. It's not with the suggest that there's a lot of difference in my chief examination. And P7 and 8. It's true that there's no mention in P7 that I went to Tory shop on the instructions of my SE. It is true that myself and LW14 did not go to the police station. So I ensured a speed at 30 route drafted XP27 and the Panchrama was heading to about 1. I went to toy shop by letting the TV. It's not with suggest that Atkins did not lead us to the place where he was living the stolen property. It's not with the parents that I wanted for to have a case on their instruction. It's not with suggest that your Panchrama was in the presence of myself and then there was booking and then my family was in focus. It's true that the articles similar to 25 to 28 are available in the market. And 25 to 28 are bloodstain and bloodstain articles are not available in the market. It's not with Salisa, that's from the state. But it's not with bloodstain articles are also not similarly at the subject. Lodges have kindly turn to the evidence of media in your lodge. So it's the doctrine of the deceased. The relevant portion is at page 16, which says that on the same day of the incident, the articles were recovered and the accused were arrested. Therefore, the place of arrest, time of arrest, date of arrest, there's no consistency. Page 16, your lodges.
Cross-examination.
Page 16. Line about 5. It is true that the accused was arrested and almost 1 to 18 were seized on the date of incident. But the arrest was shown on 17. Incident occurred on the intervening night of 12th.
Arrest was on?
17. 17A. Therefore, the recovery is also falsified with the evidence of PW. And according to her, page 15, your lodges, the last line. It is true that police arrested accused near my house, but the arrest was shown in some other village in Tamil. But the recovery is also not beyond expected out, and the recovery identity of the recovered ornaments is also not declared out.
But there is a finding by the trial court. Paragraph number 20, page 126.
That accused has PW has claimed those on, but Lodges gives evidence only. Lodges may kind of turn to the first information report at page 42. The last 3 lines. నా తల్లిదండ్రులు వేరేగా ఉండడం వలన వారి దగ్గర ఉన్న బంగారం వెండి ఆభరణాలు మనం ఎంత నగదు నాకు తెలుసు. In those circumstances, he can't claim whatever is recovered at the instance of the Apart from that, also it's a case of circumstantial evidence for lodges. They are recovered cannot be accused with the crime. And from the scene of occurrence, footprints have been lifted here. Prosecution failed to prove by sending those footprints. Though the chapel was recovered at the instance of the accused, your lordship, the prosecution failed to commit that.
MO 26, each chapel, right?
And exhibit P12 is the lifting of the equipment that's.
P12 is photographs. Photographs and photographs.
And the chapel of the accused was also recovered at the instance of the accused. But in spite of that, prosecution failed to carry. Now, it's a case of circumstantial lordship. All the circumstances should be corrected. And the
Trial court referred 4 circumstances. And according to the trial court, the same.
the other evidences, there is 7 your lordship.
Who is it? Who is it?
Says that has seen the accused near the scene of the occurrence at the time of the incident. Now, his evidence cannot be relied upon.
Right?
Now, according to him, he says that he was residing right opposite the house of the deceased, and while he was coming,
Anyway, he turned hostile. PW was second turned hostile.
in spite of that, his evidence was relied upon. Now, accused is also resident of the same village, same area. So
Paragraph,
his presence-
page 124, paragraph number 18.
Nothing was suggested to the witness that the house of the accused was not near the house of the deceased. In fact, it approaches for a moment for this page number 25 PW7 unit. My house is on the opposite side of given and scene of offense. In the month of August 2016, I went to Hanuman temple and while I was returning at about 11:30 p.m., I saw accused standing in front of his house under a niche. The distance from the house of accused and given and is 2 or 3 houses away. On seeing me, accused tried to hide himself behind the niche at about 8 a.m. So this circumstance cannot be taken into consideration because accused house is also nearby the scene of offense. That by itself cannot be said that it's the context. And his PW7 evidence is falsified by the evidence of PW1 your lordship. According to PW1, PW7 houses at a far distance from the house of the page 30.
Cross-examination.
Cross-examination. Line about 4, it is true that LW5 Malaya is PW5. LW7 is Mumaya, that's PW7. And Venkatesham is PW8. It's far away from the house of the deceased.
House of my deceased face.
Therefore, his giving reasoning that he has seen the accused while he was coming from the Vajna while he was going to the house is falsified by the evidence of the patient.
Yes.
So the main incriminating circumstance about the recovery has not been put beyond reasonable doubt. And the bloodstained clothes and the sickles, they have not been sent to the FSL to connect the accused with. The identity of the jewels have not been established as that of the deceased.
That's all? Yes, ma'am.
Case, your lordship, this section 8 is also there, your lordship. Recovery of MO1 to MO18 is from as the instance of the accused area. That should be answered by the accused because your lordship.
Who is the punch witness?
PW10.
Ramchandra. Now read his evidence again.
PW8.
PW10, Ramchandra.
10 and
10 or 8?
10.
10.
Page number 30.
Who is LW14? LW14 is
LW14 is punched to confession from recovery.
but he was not examined for this. Next.
Shall I read the evidence of PW?
Not necessary, we have already read, right?
So according to the evidence, your lordship, recovery is there. The main thing is that recovery of MO1 to MO18 is there, your lordship, which is she identified by PW1. She said that but as she lives separate from her in-laws, she specifically don't know about the amount, your lordship.
Who is she? Not she, he. Satyanarayan. son of the deceased,
In PW2, your
PW2, Sushila.
daughter-in-law.
She's there.
She stated that she is not having knowledge about the amount, your lordship. But about
Ornaments, ornaments,
ornaments, she identified the ornaments which were recovered from at the instance of the accused.
that's all. Okay. See what's from the.
Your lordships, you like to relying upon the suppressible judgment that we are which other except is not sufficient based on these judgment.
Macharla Ramesh. Macharla Ramesh.
Judgment which I have mostly.
Section 27 of your Indian Against. Party name is Macharla Ramesh, if I am not wrong.
Recent judgment. Delivered by this lecture. Relying upon the Supreme Court judgment, your lordship, which I have referred to 2022 library.
Madam. Yes. Check. ఇది అయిపోయింది చూద్దాం. And appears for appeals, recorded list on 11th December. If we invite the station call for the record board, we don't prepare for the. Yes.
Giving the petitions and form to, so now he is admitted in hospital with actually
Why? What is the problem? So we have listed it on 11th December.
We get lordship suspect, is coming for suspension sentence of legal matters.
20th. TSHC 20th. And the record also we have not received, we are calling for the record. Yes. Record we have not received. Did you file the depositions?
No.
Huh?
I filed by next
At request of land council for appellant. 4th December. 10th Monday. 20th let the 4th December. 20th December. Yes. Next.
Your lordship, I'm representing the petitioner in this case. My senior counsel is Anton. So kindly request if you take short days.
No?
Kindly request if you take short,
What is the shortest possible date according to?
maybe 5 months,
Huh?
2 weeks.
At request of land council for appellant. List on 4th December. Yes. Call for the Russian document. Paper book is ready. Paper. 20th. At request of land council for appellant. List on 20th. Collect paper. Yes. Paper book is ready. Not collected. Please collect 20th. At request of land council for appellate, list on 20th. 20th equipment. 45 it would be. 20th.
My pleasure. Lord's, this case has been filed on some page, 302,
Did you collect paper book?
Yes.
Madam, prepared?
The deceased is the mother of the accused and the complainant PW1 and PW2 are also the children of deceased.
No, complaining. Please come again.
PW1 is
PW1 is the
son of eldest son of deceased. And given for the Accused also is
PW2 is the daughter.
daughter. Accused is the youngest son. Not this entire case.
Motive?
Motive they are telling that for a year he has given his mother.
Very good.
Not because no direct witness, only circumstantial evidences are there. Even though
One second, basing on circumstantial evidence, he can be convicted.
means here that everything, even though the statements of PW1 and PW2, 3, 4 are conflicting, whereas with the PW8 is PW1, PW3 and PW4, they told that they have accompanied PW1 to the police station to file the complaint. Whereas PW8 is clearly stating that only PW1 was there.
What is the date, time and place of incident?
Time was around 11:45.
11:45.
Yes.
Place
at home itself.
Home.
Yes.
Where was accused at that particular point of time?
Accused, he's a farmer as well as a cab driver also.
Correct. Where was he?
He was not at the home. When he came.
Which witness spoke about that particular fact, saying that he was not at home at the time of incident?
Accused himself, he went that when he woke up, he tried to wake up his mother, she was not responding. So he went for assistance.
Accused himself.
Yes.
So therefore, he was there in the scene of offense at the time of incident.
At that time, exactly, it's not being given. When he came home, he saw that his mother was not responding. So he went for assistance from PW3. And he informed that my mother is not responding.
Who is PW3?
PW3 is his neighbor.
What about PW1? Where was he? Elder son?
Elder son, he was not there, my lord. He was in Hyderabad. Yes, my lord.
Daughter PW2?
She was also in Hyderabad. My lord, here.
Then we'll go to PW3 evidence. State. PW3 evidence.
PW3 also is statement about PW accused statement. Accused went to him and they called an RMP doctor also. But the RMP's doctor's statement has not been recorded.
At first, we thought it was natural death.
Yes.
In the morning hours, when PWs 1 and 2 observed the ear studs on the dead body were missing, they questioned the accused. We have also asked the accused, on which he revealed that he asked for ear studs of his mother to purchase a vehicle. That is the motive.
Not here. PW3 is nowhere concerned. He's not at all a family relative. He's a neighbor.
Correct.
But he's stating that that ear stud was missing.
That is the inquiry they have done with accused number one. Accused.
When even though in the PW1 statement also showing the same thing, that when they got suspicious, when they inquired the accused, he revealed that yes, he has stolen that ear studs and he has killed his mother. But whereas at that time he has not collected that earrings. He has shown the earrings, they are telling that PW1, PW2.
On what basis conviction was recorded?
Conviction was recorded on this circumstantial evidence. So these 4 people, PW1 to 4.
1 to 4.
Yes. And even though my lordship may see that PW8 statement.
Who is PW8?
PW8 is the IO. The cross examination of IO is clearly telling that I received the CD file on 22/3/2022. PW1 alone came to police station, whereas PW3 and 4 they told that they accompanied with PW1. I have no idea whether the complaint was written in the police station or it was bought by PW1. It is true that the signature of the complainant was not taken in column number 14 of the file. And below, PW1 was examined at police station. PW1 did not say before me that he observed black mark on the neck.
Please come to page 16, doctor's evidence.
It is so that it has been throttling a lot. But one more thing about PW1 and PW2 and 3, they are telling that there was a nail scratch on her neck. But doctor itself also has clearly told that in this cross examination, I did not record the age of the nail print seen on the dead body. It is true that as per my observation, there was a single external injury. The entire
small contusions, that is nail prick on both sides of neck.
Yes. But even though they have not concluded the mental test also of this 9 weeks, the entire case realized, even though a lot, PW accused informed PW1 and PW2, whereas they are stating that no, the neighbors, the caste people, they have called them and they have informed it. Even though last occasion also will not inform the Honorable Court that this PW1 and PW2, they are regularly visiting to the jail and they are demanding him to give his share that so that we can.
We are not concerned with it.
Yes.
We will go by the record.
Go by.
This is appeal.
Yes. My humble submission is that not there is no direct evidence. Everything has been framed. Even though not that PW3 and PW4, their land is adjourned to accused land. So they are also interfering into my land. So entire cases depend on circumstances.
Yes, ma'am.
At first PW1 and PW, they thought that is a natural death, but at the instance of this, accused only informed that he killed a mother for the ear studs, your lordship. That is
It will recover ear studs from
the
number one.
in evidence of PW7.
Once again, who is the punch witness for recovery? PW7. Who is it?
He is a resident of the same village.
Read page 17.
Page 17. I'm the resident of Narlapur. I know the accused. I know V. Madhusudan, LW11 on 23/3/2022. At about 10 to 10:30 a.m., police called me to the actual of the accused. Accused was present there. I inquired the accused, on which he stated that he killed his mother for money and took away her ear studs. But on the next day morning, his caste people called the police and on such he went to the agricultural desk. He has produced the said ear studs from his pocket, from his pants pocket. Police recorded the entire proceedings under confession, season, Panchnama and seized the ears.
That's all.
But my submission is that actually at the time of the death, they have called an RMP doctor also. That RMP doctor was not examined.
He's excellent.
Anyway, quality investigation, you can't do. They are committing so many mistakes. That's all.
Let's see. With love with artist, land counsel for petitioner, public accused and land
item part A. Paper is not ready. Paper is not ready.
20th or 4th? Request of land council for appellant list on foot in the main values to say prepare yes.
Yes. The because for the last piece, A4 and A6. The one is the she gave the complaint, facing on the.
1 second. Madam, ready?
Attending the papers.
She has filed depositions along with the appeal. If you have not prepared, tell us. No,
Would have
day after tomorrow, 14. Appeals, 14 appeals. Yesterday we have heard bills, today we are hearing bills. It's already 14. Request of land assistant public prosecutor list on 14th.
The paper book.
Fourth. Both are connected. List on 4th. List is direct to call for the record and prepare paper. I could pass out. Yes, complete.
December.
So, Lordship, now the instructions, your Lordship, taken.
What instructions?
Regarding the health condition of A1, he is suffering from a mental disorder. And A2.
After. Much of it was right. 7 at request of land assistant public prosecutor list on Thursday. Item 8.
Item 8, 7 and 8 are connected.
7 and 8 connected.
No, sir.
8 is different and 7 and 1 second. 7 anyway we have urgent to day after tomorrow. 8. 8, what is the urgency? Medical ground. In medical ground 8, what is the disease is okay? Yes, madam.
Refer to the other hospital for further evaluation, your Lordship. So for that we need to time, your Lordship, for getting this right.
Federal is going to expire today. Due to, 1 second, due date of surrender on expiry of 9/11 is nothing. 9th కదండి. Not today, 9th. Page 4 చూడండి.
Orally it is said that your on submission, your Lordship, orally it is said that that can be treated by the medicines also. That's only as kidney stones he is having, that can be, but oral information I'm having your.
We'll list day after tomorrow.
Tomorrow.
Final hearing day, ఇవన్నీ ఇంటే ఎట్లా డెడికేటెడ్ ఫైనల్ hearing day. ఏం చేస్తారు? Federal, మరి మీరు అడగలేదు. This is bail application.
Suspension of the.
89. Okay, sure. This is an extension. So we will extend the parole up to 15. We will list it on 14. 389 application, we are doing all these things. Angel, this request of land. Next.
I received the oral instructions, which is not having any antecedents. A3.
No answer. So we'll pass orders. Let's see. Vivek Jain, Land Council representing Mr. R. Sultan Reddy. Land. Yes, senior.
Sorry, my lord, funding.
We have. See, yesterday we have discussed.
Funding was also, yes, yes. Yesterday also, my lord,
The
the booklet.
problem is with special bench. Anyway, this week we are going to complete.
Today is.
Did you collect paper?
Yes, I'm having it.
Madam, ready?
The millet,
This is
this is the bail petition, first bail petition, millet, first and second, both are pending, millet. Along with the appeal, one petition is filed and millet, which could not be considered. And
That's IA1 of 2022 by accused number 1.
that's
Sorry,
no, this is millet, A3 millet, the petitioner millet.
1 second. IA1 of 2023 filed by A2. IA1 of 2022 filed by both.
No, millet. Now the present application. No, millet, the present application is filed by Vinod. 1 of 23.
IA1 of 2020.
23.
You are not pressing IA1 of 2020.
No,
We are dismissing this. Sri C. Damodar.
it is both. No.
Sri C. Damodar.
One with this. Is appellant number 2, A3. A3. That is why Virat will not. Virat.
Mere A1 Rash. Mere A1 Rash. If you go by record, is
appellant number 2, not A2.
Appellant number 2.
The present appeal 51 filed by both the accused A2 and A3.
Right.
Letter.
What happened to A1?
A1 is also Virat pending. It's
What is the offense?
it's a 448, 302 and Virat.
34, 201, 307.
Yes.
Right?
Yes.
He was convicted for the offenses.
And so far as this petitioner is concerned, Virat, since bail is over, Virat, I need to argue the matter.
Other nimshal we can wait.
That
Not we. I mean, Japan, we don't have BP sugar. We can sit for 10 more minutes.
Yes. That may only the first submission would be Milad. In the exhibit P1 report, Milad, there is no name of the petitioner. Even A2 and A3, no names are there except A1 and his friends. That was mentioned therein. No motive in respect of these petitioners. And no test identification parade was conducted because they are strangers to Milad, the witnesses.
Is there any specific overt act against this?
No.
No.
Only thing is, Milad, according to even subsequent to in the evidence before the court, they said, Milad, they caught hold of the deceased and A1 bet. A2 and A3.
A3, where is that evidence?
Milad, that is Milad, PW2 and PW10 are the Milad, the witnesses.
Let us see PW2.
Is the PW2's presence is also
page 14.
Page 14, Millard. This is Millard. The motive attributed Millard against A1 is Millard that in respect of pet dog, Millard, there was a quarrel between them prior to this incident. In respect of pet dog of the Millard, and that.
A1 is our neighbor. Previously, we lived weaker section colony, Indrasham, Patancheru. My sister. So, where is the allegation against A3? In PW2 evidence. PW2 evidence.
Millard, that is at Millard.
Same day, compromise.
Page 15, Millard.
A1 bet my mother on the face. PW15.
Page 15, Millard. Fourth line, Millard.
A3 were also present along with
A1, both of them obeyed.
My mother with stones.
Then my mother raised cries and called my father. At that time, my father was sleeping on a cot. Then A3 entered into a house and pushed my father while he was getting up from the cot.
This is the father or mother?
Father. And the mother is Millard, PW10, she is injured witness.
And therefore 307.
307.
getting up from the car. A2 and A3, please read for them. A2 and A3 tightly caught hold my father. A1 bit my father, mother. With pedaling.
Milord, page 50, your lordship may kindly see the FIR
50.
50, Milord. This is given by Milord PW1. నేను సో బొంబాయి కాలనీ ఆర్సీపురం నివాసుడు. మా అక్క రేణుక వయసు 30 సంవత్సరాలు, మా బావ శ్రీను వయసు 35 సంవత్సరాలు. 8 సంవత్సరాల క్రితం ఇంద్రేషన్ కొత్త కాలనీలో ఇల్లు కట్టుకొని పిల్లలతో కాపురం ఉంటున్నారు. వీళ్ళ ఇంటి వెనకాలే ప్రశాంత్ అని తల్లిదండ్రులతో ఉంటాడు. అతనికి మా బావకు దిస్ ఈజ్ ఆల్సో ఫాల్స్ మిలాడ్ బికాస్ ఈజ్ నాట్ ఎ నైబర్ ఈవెన్ అకార్డింగ్ టు ది చార్ట్ షీట్ ఈజ్ ఫ్రమ్ బొంబాయి కాలనీ మిలాడ్ వేర్ PW1 ఆల్సో రిసైడ్స్.
Not from Indration.
నాట్ ఇన్ ది జరిగినది. అప్పటి నుండి మా బావపై కక్ష పెంచుకొని ప్రతి ఐ మిస్డ్ ఇట్ వన్ లైన్ మిలాడ్ వీళ్ళ ఇంటి వెనకాలే ప్రశాంత్ అని తల్లిదండ్రులతో ఉంటాడు. అతనికి మా బావ వాళ్లకు కుక్కను కొట్టిన విషయంలో గొడవ జరిగినది. అప్పటి నుండి మా బావపై కక్ష పెంచుకొని ప్రతి చిన్న విషయంలో గొడవ పడేవాడు. 3 రోజుల క్రితం ఉదయం 4 గంటల సమయంలో ప్రశాంత్ మా బావ ఇంటిపై రాళ్లు వేయగా మా అక్క అతన్ని ఎందుకు ఇంటిపై రాళ్లు వేసావని అడగగా అతని ఇంటిలో నుండి కత్తి తీసుకుని వచ్చి మా అక్కను పొడవడానికి ప్రయత్నించగా మా బావ అడ్డుకొని అతన్ని కట్టెతో తలపై కొట్టినాడు. ఇటు విషయంలో మా గ్రామ సర్పంచ్ గారు ఇద్దరికి రాజీ కుదిర్చినాడు. తర్వాత ప్రశాంత్ నేను ఎప్పటికైనా చంపేస్తానని మా బావను బెదిరించినాడు. ఇట్టి విషయం మాకు మా అక్క ఫోన్ చేసి చెప్పినది. There is no Milord any complaint in respect of this incident. This is ఈ రోజు అనగా 26/7/2014 నాడు రాత్రి 1 గంట సమయంలో మా కోడలు పూజిత దట్ ఈస్ PW2 ఫోన్ చేసి చెప్పినది ఏమనగా మామయ్య రాత్రి 12 గంటల సమయంలో ఇంటి పక్కన ఉండే ప్రశాంత్ అతని స్నేహితులు కట్టెలు పెద్ద కత్తి తీసుకొని వచ్చి తలుపులు బద్దలు కొట్టి ఇంటిలోకి వచ్చి నాన్నని కట్టెతో తలపై కొట్టి చాకులతో చెవులు పోసినారు. దిస్ ఆల్సో మిలాడ్ ఫాల్స్ మిలాడ్ బికాస్ నో నైఫ్ వాస్ సీజ్డ్ అండ్ మిలాడ్ ఈవెన్ ది ఇంజురీస్ ఆల్సో నాట్. పక్కన ఇళ్లకు తలుపులు పెట్టినారు. అమ్మను బయటికి గుంజుకుపోయి రాళ్లతో కట్టెతో కొట్టినారు, పారిపోయినారు. మా నాన్న మళ్ళీ ఈ విషయంలో మేము అంబులెన్స్ లో మా అక్కను పటాన్చెరు ఆసుపత్రికి తీసుకుని పోయినాం. ప్రశాంత్ మిలాడ్ దిస్ ఈస్ Milord, the no names of the petitioner is not Milord, neither A2 or A3 Milord, not figured in it. Milord, the evidence you lordship may kindly see PW2's evidence and PW10.
Who is PW2 anyway, Pujita.
Pujita is Milord, she is Milord, she is staying in hostel and studying Milord. I am resident of Arsipuram village, Mandal, Rangareddy district. PW1 and LW3 are my maternal uncle. LW4 is my uncle. LW5 is our neighbor. LW6 is elder brother of so and so. I know LW7 and 8. I know A1 to A3 here.
Please back to page 15, Mr.
Yes, Milord. That Milord, just now I already informed you that thereafter I informed incident to the so and so. Here, Milord, she was Milord.
Even with my mother on her face with a pestle.
With a pestle.
Try to close the door. And again, even bit on her hand with pestle and dragged my mother outside of the house. A2 and A3 were also present along with A1 and both of them bit my mother with stones.
Milord,
Then my
cross-examination. The cross-examination. I studied up to 10th class. I studied in KGBV school, Tellapur. It is true I used to stay in hostel. It is true the incident took place in the month of July. It is true by the time our school was started. Witness adds that as I was suffering from fever, I was also. It is true generally our warden used to take ill health children to the doctor for treatment. We have obtained permission from our school principal to leave the school. I have no idea as to how my how many houses were there in our colony on the date of incident. It is true our house is located at outskirts of Indresham. I do not know whether there were several houses in our colony or lying vacant. I do not know whether some thefts taken place in our colony prior to the alleged incident. No complaint was given to the police at the time of quarrel took place regarding the pet dog and so on. It is not true to suggest that I did not say it before the police regarding quarrel took place regarding pet dog of Avon. I do not know whether police came and inquired basing on the complaint lodged by so and so. The middle millard, your lordship can get it, millard. It is true, prior to the alleged incident, I have not seen A2 to A3, A2 and A3. After the millard, you lot got it, millard?
Yes. After the alleged incident, police have shown it, not shown A2 and A3 to me.
Nice. Millard, according to Millard, the PW10, here the first complaint is that Millard, they bolted the houses, Millard, from outside of the neighbors and not, they broke open the Millard door, main door, and entered into the house. Millard, here the witnesses says PW10 opened after knocking the door, PW10 opened the door. Millard, page 34, you lordship.
We are at 34.
Yes, ma'am. Presently, I am resident of Ramchandrapuram village in Mandal Rangareddy district. Previously, we are residents of weaker section colony in Indresham village.
You can
this is
page 35.
Yes.
10th line.
No, no, last line, 34, last line, you learned.
Then I
opened the door and found A1 to A3. Immediately, A1 bit me with a pestle on my left lower jaw and forehead, and I also received injuries on left chin and right hand. They also dragged me outside the house. A2 and A3 pelted stones on me and I raised a hue and cries. At that time, my husband was sleeping in the house and caught. On hearing my cries, he woke up. A3, who is a fat in personality, pushed my husband onto the cart. A2 and A3 caught hold of my husband and A1 bit my husband with the pestle on his forehead, the left ear of my son. It's a totally contradictory millard from the first information. Due to fear, our children hidden beneath the cot. After beating the accused persons went into the kitchen and leaked the gas from cylinder so as to screen away the evidence and create a story of cylinder burst and the left house. While leaving our house, the accused persons kicked me on my stomach to ascertain whether I was alive or dead. So also. Then I went to my husband and called. Thereafter, I went to the house of PW 527 to call them. We knocked the doors of their houses, but they could not open the doors since their doors were bolted from outside and removed bolts and so on. So PWs 527 and others of also injuries, and we fell down in front of our houses. Thereafter, so on. Millard, this is cross-examination, Millard. It is true, government has allotted house to us in weaker section colony. We lived in the said colony about 8 years. I do not know whether it was newly formed colony. It is not to suggest that as it was not newly formed colony, as roads and drainage also. We did not file any complaint to the police regarding the pet dog dispute of A1. So also at the time of
the compromise,
it is not.
Pet dog incident compromise అయిపోయింది.
No incident is there is no question of now. Compromise theory, that is Millard to involve Millard Sarpanch into the scene, Millard, that false story, Millard. In fact, Millard, it was a dacoity case. Millard, that was converted into Millard because there is enmity between Millard PW1 and A1 in the Bombay colony. Millard, the charge sheet address you lot, the police have called page 1. Uppu Prashant, resident of so and so, Bombay Colony, RC Puram. And the IO evidence also clearly shows neither he seized Millard the gas cylinder from the house.
PW15 is the
IV, yes, Millard. At page 47, Millard. And I am working as Inspector of Police, Traffic Police Station, so and so. Millard, previously I worked as Inspector of Police, Patancheru, from so and so. On 26/7/2014 at 6 a.m., I received written complaint under Exhibit P1 from PW1. Basing on the same, I registered a case in so and so. Exhibit P11 is the FIR. On the same day, I visited the scene of offence and conducted scene of offence Panchanama in the presence of PW11, so and so. I have recorded the statements of PWS 129 and on the same day I have conducted inquest Panchanama on the dead body. I sent the dead body to the Gandhi Hospital, so on sort of. On 28/7/2014, on credible information, I have arrested A1 to A3 SN Colony, Ramchandrapuram, and brought them to Patancheru Police Station. I recorded statement also A1 to A3 so on. And the seized M was 1 to 12 Millard at the scene of offence. Let cross-examination, it is true PWs 1 to 4 and 10 are family members. This witness at PW2 and 10 are eyewitnesses to the incident. It is not true to suggest that PW1 and A1 are neighbors in Bombay Colony or Sipram. I did not visit the house of PW1. No test identification parade was conducted, so on so. It is true A2, A3 belongs to Bombay Colony or Sipuram. I have not collected fingerprints from the scene of offence. Blood. I have not examined the warden of PW2 where she was studying, whether she was in hostel or in Millard. One of the witnesses says Millard, only one son, one daughter were present in this. The presence of PW2 is also doubtful, Millard, because they did not speak about it. Millard, the FSL report, Millard, says the clothes of the Millard accused were seized under MO12. Millard, the FSL reports clearly says Millard, no blood, human blood is Millard. That Millard page 90 Millard. 90. Blood is not detected on items number 8, 10, 12 and 14. Millard, in the judgment you wrote and the PW2's Millard information, Millard, you wrote page 92. Gandhi Hospital, she reported the alleged incident, alleged to have been beaten up for unknown disputes. And page 161 Millard, MO12 cloths of A1 to A3 Millard seized that are marked as Millard MO12, where Millard no human blood is. And so far as the allegation that Millard the Kattulato Chevu Posnaru and other things Millard, they absolutely no knife was seized and no, there is no evidence with regard to that, though it was mentioned in FIR. So with all these Millard contradictions and Millard and the evidence of PW2 and 10 Millard is not trustworthy and Millard all are interested witnesses and Millard so far as this petitioner is concerned Millard is stranger to them, no test identification parade and Millard his involvement is not there because his friend of in Bombay Colony Millard he was implicated Millard therefore he is entitled for bail.
There is nothing to dispute the evidence of PW2 and PW10. PW10 is the injured witness here. And regarding that, there was a motive, Your Lordship. Previously, two quarrels took place in between them. Panchayat was held regard to that. That's why FIR was not passed. And second thing, your lordship, there was a pre-mediation is also there according to the PW 10's cross examination. While they coming to the house of the deceased, they bolted the house of the neighbors from the outside. That's why they went, when they asked for the help, they had to open the door of the neighbors and then only they came for the help. That motive is there, mediation is there. And regarding the test identification parade, your lordship, that is explained in para 33 of the judgment.
We have read para 33. We have.
Yes. That about the test identification explanation is given.
The manner of Millard, the attack Millard, as mentioned in the Millard entire prosecution case, Millard, this happens only when Millard a dacoity is taken place. That is your lordship well aware. It's a dacoity case, Millard converted into Millard.
Then comes a petition public A3, and the grant asked public loss.
Millard.
Because we have this we will list it on.
Millard.
Did you find your depositions?
No, Millard, booklet is there, Millard. In fact, this was argued in the March, Millard, before his lordship Justice Abhishek Reddy and Sridevi. And they reserved for orders and then.
Yesterday we have inquired with the registrar. 2023 matters we are receiving paper book. In 2016-17 matters we are not receiving paper book. We have called him as.
Yes, what happened, Millard, earlier, the Honorable Chief Justice also, Millard, heard these criminal appeals. And at the admission stage itself, Millard directed most of the cases that Millard paper book is to be prepared within.
But that's what we are
So
doing.
that's.
Even on the day of admission.
That's
See, in one matter yesterday, we have directed the registry to call for record 3 times. It was not called 2017 appeal. We'll see. 14.
No, that, Millard, Thursday, Millard.
Deposition చేయలే కదా మీరు.
No, Millard, booklet is there, Millard. Yes, Millard. This is, Millard, we argued this, Millard, twice. Almost 2 months, Millard, before his lordship, Millard, Justice Abhishek Reddy. It was reserved, and thereafter, Millard, then the subject was changed, Millard, it was released.
15 and 16 ballots are connected matter. Lordships.
Item 16 is connected.
Yes, ma'am.
Millard, there are 6 appeals.
One of you, not both of you, all of you.
Ma'am.
6 appeals are there.
6, Millard. 169, 175.
There was no
Able to-
representation.
I apologize.
Please apologize. See the type.
I apologize.
But you are holding as a.
Apologize. Honor. Both will be got together. Apologize. Sincerely.
When do you want?
There are 6 accused, 6 appeals are there.
Give the numbers. We will list all appeals on 14th.
No, Millard, it's there, Millard, in the list. In the final hearings list, it is there, Millard.
Two appeals are.
Only 2 appeals are there. 175 as well as 169. That's
No,
all.
Millard. Next final hearing, Millard. Kindly see. Because last occasion also,
The numbers, we will list all the matters day after tomorrow.
yes, Millard.
14th,
Criminal appeal 169 of 22,
169 of
22,
22, number 1.
175 of 22, 222,
222.
279, 301, 362.
So all are there in the list today.
Yes, Millard.
14th.
You are there in this, Millard, and intellectually, and the others are final hearings.
List on 14th. 14th. Paper book definition. Yes.
And let them inquire, Millard. The bundles are, Millard, paper books are, their residences are, Millard, in the court.
Residence question is your residence.
His Lordship Justice Abhishek Reddy heard this. Because thereafter, when it came up before his Lordship, say M. Lakshman also, Millard, the files were missing on that day also.
For us, files won't miss, don't be. 14th, bundles will be there in the, right, paper books will be there in the body.
Make a mention.
Sorry.
Item number 93. If petitioners have filed a petition for modification, for 1 week time, I can be granted for paying my account.
93.
Early access products, so Thursday, the lot can take it out.
93 at request.
I have no holidays for the school also.
One second, don't argue. Otherwise, we will raise and go. At request of Land Council for West Bonnet, list on 16.
That is the item.
Parties present. Custody of children, parties present.
Party ఏం చేయాలి పార్టీ ప్రెసిడెంట్ మేము రమ్మలేదు రమ్మన్నామా
Last occasion,
మేము రమ్మన్నామా ఇస్ దర్ ఎనీ డైరెక్షన్ ఓరల్ గెట్ ఎందుకు డిలే ఐటమ్ నెంబర్
75.
75 75 75 Thursday
That is item.
75 you have to inform other side Mr. GB Shivaji 75 request of CK Venkatesh Gupta list day after.
Item two.
Come day after tomorrow. Day after tomorrow.
Item 254, your lordship. 254 item. It is listed in final hearing matter, bail application.
Bail applications.
Bail application.
20th.
Yes.
Give the number.
Is the item 254, your lord. Item 254.
Number here they are online.
16
Ah.
I made a mention in the morning as 25.
What do you want? What do you want? Why?
92 euro.
So he is with the brother. What is the problem? No, we'll hear you day after tomorrow. Tomorrow is the dedicated final hearing.
Kind permission, my lord.
1 second, Mr. Dugaps. What do you want? Huh? Why? Why you top of the list? There are several IAS. Why you are asking for top of the list? Right. Day after tomorrow.
I apologize for
Yes,
this.
Mr. Dugaps. Dugaps, sir.
Item number 58, my lord.
What do you want?
It may be taken up next week, my lord, because the counter is not ready in that.
Did you inform other side?
No, my lord,
No, without information, we will not adjourn. Yes.
much obliged. When the item arrives.
మూడు కాపీస్ just కింద. Yes, ma'am. Before, my lord, referring to the judgment, have not covered the three important topics, my lord, with regard to the phone calls and also PCO phone calls. The accused A2 and A4. A2 landed in Hyderabad. He traveled to Hyderabad. He made a call from Kukatpalli PCO, public telephone, my lord, to the number of accused number 4. So that, my lord, the call records were also collected, my lord, I am submitting for consideration, because as to the phone number of, my lord, accused number 4, only used 2 phone calls at Hyderabad, that is Kukatpalli PCO and another PCO call at LB Nagar. Except these 2 phone calls, he only used for internet. No other phone calls he has made. So, my lord, I am placing, my lord, the lordships, these are, I am giving the notes for consideration, court of Sri. Even in the confession also, my lord, this is the very crucial evidence about the arrival, movements of these accused prior to, my lord, the blast. My lord, the exhibit P192, the confession of, my lord, accused number 2, Asadullah Akhtar. My lord, paragraph 4 is the relevant. On the instructions of Riaz Bakhtal, I booked my ticket revealing my identity as a Danish through VRL travel agency in Mangalore and left for Hyderabad. On 9th February 2013, about 2 p.m., I reached Hyderabad. On next day, 10 to 2013, around AM, I got down from the bus in Kukatpalli area, contacted Hassan from nearby PCO. Hassan is accused number 4, my lords. Informed him that I have reached Hyderabad. He told me to come to LB Nagar. I proceeded to LB Nagar in an auto. After reaching LB Nagar, again I contacted Hassan Tazeen Monu from PCO situated near LB Nagar, crossroad so and so. After receiving the call, Hassan was already waiting at LB Nagar crossroads, came and took me to shelter place situated at Abdullahpur, followed Ramoji Film City. My respectful submission is, A2 traveled from Mangalore to Hyderabad, my lord, that is marked as exhibit 202, my lord, volume so and so. My lord, after, my lord, getting down at, my lord, the Kukatpalli, my lord, he contacted A4, the phone number, my lord, the phone number, 99 so and so, my lord, from a PCO Kukatpalli, my lord, phone number, so and so, which is marked as exhibit P205. My lord, another phone call to the same number of Hassan, 066, my lord. He called again 066 to from 1745 number at LB Nagar crossroad, which is marked as, my lord, the same exhibit P205. The contact details are there. My lord, thereafter, my lord, Muhammad Fazeen Akhtar A4 used fake ID card of Ravindra Sharma to obtain the SIM card, which is marked as an exhibit P206. My lord, A4 used the SIM card for internet purpose. He received only 2 calls from communicating with A2 at Hyderabad, except these 2 phone calls, my lord, which is impersonated in the name of, my lord, some Sharma, my lord, Ravindra Sharma. So, my lord, he was also examined. So, this is the, my lord, the crucial evidence of the PCO phone calls, for which, my lord, the cross-examination was done, my lord. These were not, my lord, disposed. And phone calls also, my respectful submission, page number 2636, we marked also. Lord, page, this is volume number 7. Lordship, kindly, this necessary. These 2 are very crucial. Page number, volume number 7, page number 2686. Exhibit P205. 2686, my lords. ఇదే కదా 666 around. Yes. Well, these 2 pages reflect all the usage is internet, except these 2, my lord. I'm sorry, my lord, this is lordship may see, my lord, this, my lord, the way the from the top, my lord, Lordship may see there are the two phone numbers 500 500. Lordship got it, my lord. 10th line, my lord, 10th from the upper side.
2686 or 2687?
Yes, no, my lord. This is 2686, my lords. 2686. From the top, my lord, it might be 10th, my lord. There are two, second row, 500 is there, 500. And another one, 745 immediately next. These are the two calls. And my lord, the other, the call records totally shown as internet, my lord. Yes, column number 3, my lords. Everything is in internet. So these are the Hyderabad calls we established, and the fake ID, my lord, the SIM card was also used by Ravindra Sharma, in the name of Ravindra Sharma. That was also examined, my lord. So this is an important evidence with regard to PCO phone calls, my lord. I'll write in a, my lord, written arguments also this aspect as a special heading. My lord, the other thing is, I'm submitting that, in fact, I orally, my lord, said who, my lord, by referring to the, my lord, the volumes, which is, my lord, a small difficult task, my lord. So therefore, I, my lord, arranged in, my lord, the tabular form which witness has identified which accused. So this is in, my lord, what is their evidence. My lord, the list of witnesses who identified the accused in court and etc. My lord, the first one, my lord, the first detail is, my lord, with regard to accused number 2. A2, the second column is identified by PW55, my lord, is a Venkateshwarlu neighbor so and so, wide exhibit P45, exhibit P121 so and so, Abdullapur house owner, relative and neighbor, and my lord, PW56, Kaza Pasha, my lord, wide P47 so and so. My lord, I say in nutshell, PW55, PW56, 57, 58, 60, 62, 64, 65, 67 and up to 99 to 141. These are, my lord, the reference to the exhibits mark, the gist of evidence, the, my lord, the nature of evidence also, my lord, we mentioned at the, my lord, the last column. So, my lord, the how they are related to this and what are the exhibits marked and page numbers and etc. And next one, my lord, A3, Ziaur Rahman, my lord, PW55. My lord, no need to refer all, my lord, description already in length I already submitted, my lord. PW55, 58, 64, 65, 67, 68, 70, 72, 73, 112, 116, 118, 124, 126, 127, my lord. The next one, Mohammed Tazeen Akhtar A4. Mohammed Tazeen Akhtar A4. My lord, the PW 54 and 57, 58, 59, 67, 82, 83, 116, 118. My lord, Siddhi Bapa. My lord, A5, PW 72, 81, 99, 131. My lord, Aijaz Sheikh. My lord, PW 111, PW 147. My lord, these are all in, my lord, the tabular form, which clearly establishes the prosecution case against all these accused. So my further submission is, my lord, as far as these things are already, my lord, all are submitted in detail. With regard to the judgment, my lord, the important aspect, my lord, my lend friend, volume number, my lord, in fact, this is appeal, my lord. There is no appeal. There is no number, I think, my lord, it's an appeal. Yes, filed by Mr. Mahadevan, my lord, is submitted. My lord, the judgment begins at, my lord, 28, page number 28. Till then, my lord, all the grounds is the grounds of appeal, 28. Yes, my lord. Yes. But the judgment of the, my lord, the total, my lord, the entire volume by respectful submission is my lord, the important, my lord, the paragraphs are concerned. My lord, the almost total, my lord, 702, 704 of the paragraphs are there. My lord, out of 704, my lord, which are not so material, my lord, not so important, because the description of the charge sheet, my respectful submission is paragraph 1 to 41. These are all, my lord, the contents of the charge sheet.
Paragraph numbers,
1 to 41.
description,
Yes, my lord.
allegations, maybe.
Yes, my lord.
Maybe allegations.
Allegations, I can say that the brief facts of the case, charge sheet. Yes, my lord, allegations, your lordship is right. Yes. Yes. And out of that, my lord, the registration of the case and investigation, transfer and etc. is discussed. Paragraph 45 to 42 to 45. My lord, it is with regard to cognizance. Yes, my lord. So, my lord, these are the cognizance. My lord, my respectful submission is the cognizance is concerned, my lord. My learned friend has taken one plea that there are the two cognizances by the two courts. One is the initially the first, the fourth, the first, the special court at NIA Hyderabad, and thereafter his. My lord, my submission is as far as the cognizance is concerned, my lord, there is no bar, and even the defense counsels have not objected for that. But my lord, when the special court was constituted, the court was under the impression that again, my lord, it's a de novo trial, and my lord, the fresh inquiry. According to that, the my lord, after hearing my lord, the accused, the cognizance was taken, and my lord, if at all, my respectful submission, if the two cognizance are bad in law or illegal, we would have challenged, and there is no particular the referent my lord, cross-examination with regard to that aspect, and moreover, it has not resulted into the, my lord, the failure of justice. There is no occasion of, my lord, failure of justice. Even the cognizance what it was taken, it was not objected by the defense counsels at any point of time. It is the duty of either the public prosecutor or the defense counsel or the court on its own has to observe what are the
About dates, two dates.
dates, my lord, dates I have not mentioned. My lord. I'll give in writing, my lord. I'll give in writing. So this aspect I failed him, Lord, because he raised that aspect, my lord. My reply and my explanation, my lord, from the side of the prosecution is the two times taking of cognizance is not bad in law, because neither from the prosecution side nor the defense side or even the court has not noticed that. And moreover, it's not so big error to vitiate the entire trial. So, my lord, there is no prejudice caused to the accused. My submission is. So, therefore, my lord, and the other thing is, my lord, the 46 to 48 charges framed against accused. My lord, in fact, I have written every paragraph what is, my lord, observed by the trial court. My lord, I'm giving the separate, my lord, in written form. I don't take much time out because every paragraph, what speaks it, what reference, 9, 12, 13, and etc. My lord. So these charges are concerned. My lord, the charges, my respectful submission is paragraph 46, my lord, paragraph 46. Yes. Yes. Yes, madam. 47 contains 38 charges. Lordship, it's necessary, my lord. Lordship may kindly, Lord, peruse, my lord, the charges, because my learned friend has raised certain, Lord, the legal questions. 47. Yes, madam. Followed the cognizance is concerned, followed the paragraphs. It is mentioned, followed paragraph 44 and 45. The cognizance is explained by the so-and-so court. 44 is first additional MHA, so-and-so taken on file of cognizance so-and-so and so, madam, date is paragraph 44, madam. 44 by first MHA. And 45, this court to cognizance. And at the end of the paragraph, all the relevant documents were furnished to the accused, to cognizance so and so. Yes. Well, coming to my lord, my respectful submission is the framing of the charges. Well, the relevant is the 47 paragraph. The following are the charges framed against accused. Well, nearly 38 the contents, well, 38 contents. You lordship may kindly see. You A2, A3, A4, A5, A6 of you, along with the absconding accused number 1, Riaz Bakhtal, so and so and so, during the period 2010 and February 2000, conspired together in order to wage war against the government of India. In pursuance of waging war, you all decided to commit terrorist attacks to kill innocent people, to disrupt security of India and create insecurity feelings in the minds of the common people, which acts are prejudicial to the integrity and sovereignty of India, decided to conduct bomb explosions in India in order to commit offences punishable under 302, 307, 316, 436, so and so, Explosive Substance Act, so and so, to destroy A1 Mitch Center, Anand Tiffin Center, so and so, under 466, forgery, 474, forgery of public. But I may, because this is, but I am reading in depth. The reason is, my learned friend said that the charges were not properly framed and it's a defective charges, and more so, there were certain non-framing of charges, but there were convictions for which it is necessary to refer, my lords. And 474, possession of forged public document, 427, mischief, so and so, 201, causing disappearance of evidence, so and so, of IPC. Coming to UAP Act, my lord, section 3, section unlawful causing explosion, 5, possession of improved explosive devices, Explosives Act, section 10, my lord, is UAP Act, my lord, being and continues to be member of banned unlawful association, section 6, committing terrorist act resulting in death of any person, 17, raising or collecting funds for terrorist act, 18, conspiracy to commit terrorist act, section 19, voluntarily for harboring any terrorist act, section 20, being member of unlawful association or committing act in relation to its membership, section 38, subsection 2, assisting relating to membership of unlawful association, Indian Mujahideen. Section 39, subsection 2, supporting to unlawful association, so and so and so, 1967. Section 14 of Foreigners Act, contravening the provisions of visa, passport, and thereby you committed an offence punishable under section 120B, read with 302, 316, 436, 466, 74, 471, 201 of IPC, and section 3 and 5 of Explosives Act, and section 10 to so and so, 39 of UAP Act, Foreigners so and so Food Act, 4 of Public Property Damage Act. Within my cognizance, I hereby direct so and so. Well, these are all 38. Well, no need to note because this is the part of the record, but the relevant charges, my lord, my respectful submission is charges and charge sheet. Last, well, the volume number 1. After these, yes, my lord, before that, my lord, I request your lordships to see the judgment page number 31, the internal page number, my lord, 31.
Internal page 31.
31, or otherwise page 58.
Yes.
31, my lord, paragraph 48, ships, my lord. All the above charges were read over and explained to the respective accused in vernacular language and they denied the said charges and claimed to be tried. My lord, thereafter, my lord, my respectful submission, this is the one volume number I will read, my lord, I don't trouble your lordship, because there were, after, my lord, the time of framing charges, this is volume number 1, my lord, page number 252, 260. My lord, these are the charges under section 228 of CRPC. My lord, with regard to A2, page number 252, volume number 1, my lord, volume number. No, that copy, my lord, the judgment always remains with your lordships today, my lord. This is an additional, my lord, 252 and 228. Yes, my lord. Name of the accuser so and so. Have you received the copies of the record? Yes. Yes, my lord. The charges under section, my lord, against A2. What is being prosecuted against A2? All mentioned, my lord, he has pleaded not guilty. Do you have means means to engage advocate, my lord? Charges explained to the accused in vernacular language through the superintendent of this court. My lord, all this is page number 252 to my lord, 261. After explaining all the charges, my lord, in the language known to them, they clearly, my lord, endorsed, my lord, on these charges as were explained, my lord, by the court duly, and on these charges were framed. If really my respectful submission, even I have also referred to, my lord, various the provisions of the charges earlier I read, my lord, that 228 and etc. Even the defective charges or otherwise, my lord. So these are all, my lord, the law is very clear on that aspect, my lord, in written arguments, my lord, is a head, my lord, under the charges chapter, what the legal position and etc. I'll submit to my lord, your lordship, sir. My lord, my respectful submission is as far as these charges are concerned. My learned friend, my lord, now coming to what exactly, my lord, the alteration of charges, what, my lord, the defects in the charges, the trial court, my lord, has in detail, after explaining in paragraph 48, my lord, 49 is the relevant, lordship, my lord, the same judgment. Certain typographical mistakes were detected in the examination of the charges. Yes, certain typographical mistakes were detected. Number 31, judgment 31, my lord, internal 31 or 58. Yes, 49 paragraph. Certain typographical mistakes were detected in the examination of the charges. Hence, following necessary corrections were made in the examination and charges. Paragraph 50. In 11th charge, the word respectively was added, informed to the both sides. Next one. In 14th charge, the word other was added and informed to the both sides. In 20th charge, the word A2 was replaced with the word A3 and informed to the both sides. In 7th charge, for the offence under section 201 of IPC, there is no specific reference of A2, A3, A4. Instead, it was mentioned as you. Though it was referred in their examination, same is treated, corrected by referring A2 to A4. The word you was used, not A2, A4 in that place. And more so, this wording was there in 38 charges, my lord, the contents. So, where the signature was not taken, my lord, under 228 framing, it was not there. So, it was added. The accuser number 2, my lord, paragraph 54, was charged under section 466 and 474 and 109 of IPC, but it was missing in the examination. Hence, it was corrected. Secondly, A2 was charged under 121, 34 IPC, but in the examination, it was mentioned under 121 so and so, under so and so 2 counts, and the same is treated as corrected by deleting the word 2 counts. Accuser number 3 was charged under section 466 and so, it was missing in the examination. Well, 56. The accused number 4 was charged under section 466 and 474 and 109, but it was missing in the examination. It was corrected. Secondly, A4 was charged under 316, but in the examination, it was mentioned as under section 316 and read with 34. Same is treated by correcting, by deleting read with 34. The accused number 5 was charged under section 466, 474, 109. It is missing in the examination. It was corrected. Secondly, A5 was charged under so and so 121, 101, but it was mentioned as under section 121, read with 109, 2 counts. Under section 316, read with 34. Same is treated by correcting, as corrected by deleting the word 2 counts. The accused number 6, charged under section 466, 474 IPC, but it was missing in the examination, hence it was corrected. Secondly, A6 was charged under section 201, read with 1, but in examination it was mentioned so and so 201, 109 and 2 counts. 316 and 3 were 2 counts. Same is treated as corrected by deleting the words 2 counts. In charge number 12, it is treated to be corrected as a section 3 in place of section 5. In examination, it is treated as a 2 counts, section 3 and so and so. Paragraph 59 is the relevant the observation of the court. The above correction did not affect the merits of the charges in any manner. The court applied its mind while framing the charge, applied its mind with reference to the incriminating material before the court, and accordingly, it was done. So the legal position also under the provisions of CRPC, but all 288 and etc. and the charges I already submitted in the right also. Even non-framing or correction of charge before the judgment at any point of time, the court is having the power, but the legal position is very clear. So my respectful submission, my lord, the paragraph, the court 59 has said, even my lord, my respectful submission is 59. So therefore, with regard to charges, my respectful submission is there is no any such a irreparable, my lord, something so which has resulted in miscarriage of justice or prejudice to the accused. So therefore, it will not affect, my lord, the core of the case. So with regard to charges, the court made an application of mind and duly answered, my lord. This is my respectful submission. Paragraph 5, my lord, 60 is concerned. My lord, this is the prosecution case. How? My lord, the examination of witnesses, my lord. Total witnesses were up to PW 157. Marked documents are P1 to 507. Exhibit, my lord, material objects MO 1 to 201. My lord, all accused are examined under 313. Denied the evidence of prosecution and incriminating material. Defense, my lord, they also got marked exhibit D1 to D4. The prosecution witness so and so, my lord, so and so. My lord, my further submission is after paragraph 60, my lord, the relevancy is, my lord, paragraph 61 to 73, protected witnesses under section 17 of the NIA Act.
61 to?
61 to, my lord, 73 and 74 also. My lord, this is with regard to ensure the safety to the lives of, my lord, the witnesses in such a, my lord, terror cases. My lord, even at the time of allegations, my respectful submission, generally, my lord, the honorable, my lord, the competent court of criminal jurisdiction will examine what are the nature of the allegations. Sir, there is a, my lord, the difference of, my lord, the small charges and the grave charges, my respectful submission. My lord, the accused were charged under the provisions of UAP Act, which is punishable with the death sentences. The allegations, my lord, the allegations has gone to the stage of framing, my lord, the filing the charge sheet and taking the cognizance and framing the charges. There is a prima facie case. under section 43D5 of UAP Act. So in those circumstances, my lord, such a, my lord, the hardcore terror activities they have done, they have the previous history, my lord, they involved in number of series of cases. So prosecution moved in application under section 17 of a particular witnesses, which are most important witnesses. The court, my lord, after hearing the prosecution as well as the accused, my lord, has provided, my lord, granted the protection of witnesses to take certain safety measures, my lord, while the trial is being conducted, and also not only during the course of the trial, but also not revealing this name to the public, except to the honorable court. So this is, my lord, in the interest of, my lord, the safety of the witnesses. That is their section 17 of NIA Act, my lord. 117 National Investigation Agency Act. So, my lord, there is nothing, my lord, of course, my lord, they argued that my lord, the trial court particularly, my lord, has given, my lord, the valid reasons by discussing, my lord, the Honorable Supreme Court judgment and the legal position with regard to protection of witnesses, POTA and TADA, which are the sections of paramilitary, my lord, with these sections, and a detailed discussion by respective submission is. So, therefore, 61 to page number paragraph 74. Paragraph 74, my lord, these are the protected witnesses, my lord. 61 to 74. 74 is the observation of the court, my lord, after detailed discussion. My lord, the 73, the reasons are assigned. What my learned brother Mr. Mahadevan has argued by mentioning, my lord, the defense counsel's name and argument and etc. Every of his objection was duly considered, and the court came to the conclusion it is the necessity, my lord, to provide the protection of means, my lord, the protection of witnesses, safety measures. My lord, 74, lordship, for a minute, my lord. The following are the protected witnesses examined in this case. PW 54, PW 55, 54, 55, my lord, these are the house owners of Abdullahpur Meta, wife and husband. 56, neighbor. 58, 60, 64, these are all the, my lord, the cycle sellers, cycle contractors. 62, 72, 73 and 83. So these witnesses, because the very case, the prosecution case rests on the very, my lord, the evidence of these witnesses. Therefore, prosecution has taken, my lord, the precautions, and court has allowed, my lord, by referring, my lord, the illegal provisions. And another thing, my respectful submission. So therefore, there is no, my lord, illegality or, my lord, any impunity, my lord, in providing, my lord, the protection, my lord, to the protection of witnesses under the Act. Section 70, my lord, paragraph 75. Concerning the charge sheet and documents, which prosecution has so and so, hearing the argument of both sides, the following points arise for my determination. Lord, my learned friends, defense counsel said, except mentioning, my lord, the argument I am repeating, my lord, for the reason that the court, my lord, was not, my lord, it's not the case that simply reproduced the charge sheets and etc. Where it is necessary, my lord, he can't invent the story. Whatever the contents of the charge sheet, whatever the evidence of PW 1 to 157, where it is necessary, the chief was also recorded and the cross was also recorded. And ultimately, my lord, the reasoning was given. So the entire chief, entire cross is the part of the judgment. So therefore, my respectful submission.
Where is the finding?
No, finding. I'm going, my lord. What I'm trying to say. My lord, now the charge.
His allegation was
Yes.
trial court.
Contention against me. Yes,
trial court reproduced chief examination and cross examination. There is no finding at all.
It is there.
And in several, one second. At several places, trial court said the objection raised by the learned defense counsel will be considered at the time of judgment.
Yes.
Where is the consideration? That is not there. The legal objections which they have raised with regard to procedural aspect, there is no finding. So that is
yes, that aspect. Now, what I'm my endeavor. I'm trying to clarify to the maximum extent, my lord, basing on the record. With regard to charges, my lord, just now, my lord, I clarified there is an application of mind. Cognizance, there is an application of mind. Why, my lord, my lord, whatever the objections with regard to them, I'm clarifying. My lord, here what I'm trying to say, my respectful submission is that the Court has formulated, my lord, nearly the 30, my lord,
Choose to be decided.
yes, my lord,
Page number
page number 71, my lord.
71.
That is 44 is internal page. Your lordship is following internal or page number? 74, I can say page numbers.
Page number 74.
Yes. 74 to. My lords. Forty-three, my lord, page number 86. 43 points were framed by the trial court for consideration of the case, my lord, on record. Lordship may see, my lord, whether there was an application of mind or not, my lord, the action of the court can be inferred, my lord, from the very, my lord, the points, 43 points, for 5 to 10, my lord, I'll read for the consideration. Does the prosecution prove that? Page number 71, item number 1, my lord, point number 1. The accused number 26, along with the so and so during the period so and so, my lord, this is so and so, was a party to the criminal conspiracy and etc. etc. And all the, my lord, the misdeeds and the criminal acts that is mentioned in the entire paragraph, whether they committed the offenses stated in so and so in the charges. 2, does the prosecution prove that accused number 226 along with so and so period has waged a war against the government of India? Does the prosecution prove the accused 2 to 6 along with absconding accused number 1 within and without India had conspired to wage war against the government of India? Does the prosecution 2 to 6 along with absconding accused number 1 has conspired to war by means of criminal post or show of criminal force the central government and the state government of erstwhile Andhra Pradesh? Does the prosecution prove this so and so? These are all 38, and my lords, even my lord, table, your lordship has pointed out on my earlier arguments, where is the list of the deceased at that time? My lord, in the 6, it is the list is also furnished, my lord, by, my lord, in the so and so people you caused so and so death.
6 people at 107.
Yes, my lord, and 11 people at 11 Mitch Center. So that is in my lord point for consideration at 6. And 7, does the prosecution prove that so and so, my lord, these are all? And again, why I am referring, my lord, the issue point number 11. Lordship may see the gravity of the offence. Prosecution proved that A5 and A6 abetted the accused number 3 and 4 for the commission of attempting to murder 62 persons as mentioned in table number 3 at 107 bus stop, and attempting to murder 64 persons as mentioned in table number 3 at Mitchell Center. Lordship may see, my lord, the list of injured, my lord, the innocent people were hapless people, my lord, lordships. This is pages runs to, my lord, 4 pages up to 126, my lord, page number 81.
Injured
126. My lord, grievous, simple, most of them, my lord, lost, my lord, the vital organs of the body, living, my lord, as a dead persons after this blast. Yes, my lord. So this is all. So my respectful submission is the trial court has applied its mind, 38 my lordish points were framed. Now, my lord, your lordship is right. What are the findings on these points, my lord? I'm coming to lordship's, my lord, query, my lord, 76, my lord. Now, the crucial question.
Page number?
Same, my lord, 86, 86, after 43 point for consideration issue. Now, the crucial question that falls for my determining basing on the arguments is whether blast occurred at A1 Mitchell Center about so and so, or improvised explosive device bomb blast or not. If so, whether the deaths as mentioned in table number 1 and 2 and injuries mentioned in table number 3 are caused by bomb blast or not. In this matter, the contention of the learned counsel for the accused is that there was no bomb blast, it was a cylinder blast. And A1 Mitchell Center transformer blast at 107 bus stop. He further contended that there is no presence of whitish, yellowish or brown color substance on the injured, and injury certificate also do not mention that there were burn injuries as to establish IED bomb blast. Therefore, the injuries were not caused by bomb blast, but might have been caused by propellants of the blast, which could be due to short circuit of the electric transformer or cylinder blast at A1 Merchant Center. On the other hand, land public prosecutor so and so occurred, device belong occurred so and so, causing so and so, my lord. Paragraph 80, I am scrutinizing the relevant evidence of this aspect, and two complainants, injured relatives of the deceased, medical officers, inquest panchas, FSL experts, photographers, investigation officers, and etc. So, my lord, to decide this issue particularly, I also argued at length, your lordship may recollect. My lord, this is so and so with reference to, my lord, what the evidence of PW1, what the evidence of PW4, another complaint with the police station, and what are the, my lord, the evidence of the injured witnesses, and what is the scene of offense. Yes, yes, my lord. So the court, my lord, has lengthily and thoroughly, my lord, discussed about this and came to the conclusion, my lord, by examining all the evidences, my lord, for which paragraph 87, my respectful submission, exhibit P1, exhibit P4, who are the complainants, the complaints were examined, exhibit P2, P4, my lord, they were also examined, paragraph 87, and my lord, with regard to this, all, my lord, the doctors, my lord, the doctor's evidence was also examined. The medical certificates were also examined, my lord. After examining, my lord, all these witnesses, up to witnesses 50, PW 1 to 50, my lord, and so various. The court, my lord, came to the conclusion, this is, my lord, a bomb blast caused by, my lord, the accused, my lord. That is the finding, my lord. I am drawing your lordship's attention to all, my lord, paragraphs up to 111, the doctor's evidences and etc.
Where is the finding?
Finding. Yes, paragraph 90, my lords. 90, yes.
90 during the
No,
course.
no, during the course of science. I'm sorry, my lord. I'm bringing to lordship. Sorry. Yeah. 91 to 215, injured witnesses, my lord. And paragraph 216, my lords. 216. Yes. Well, up to here, well, from this paragraph, my respectful submission, the which I said, my lord, now all the injured witnesses to PW1, nearly paragraph 18 to paragraph 215, my lord, this is examined all the exhibits, my lord, what they have stated in the chief and cross and the observation and etc. and what they denied and etc. my lord, in the 216. That being the evidence adduced by the prosecution, that as it may, land counsel for the accused astutely contended that so many witnesses stated that the blast was due to short circuit. The blast of electronic transfer situated at so and so. There is no clinching support from the injured medical officers. Therefore, the prosecution failed to prove the beyond reasonable doubt so and so. Now, coming to the documentary evidence, my lord, paragraph 217, the observation, exhibit P1 and also PW1, my lord, and paragraph 218, exhibit P4 complaint, what I stated, exhibit P, my lord, PW2, and 219, my respectful submission, 219, the evidence of the both complainants fully corroborated with the FIR so and so and so. What they have stated, my lord, use sound bomb blast, that is mentioned in 217 and 218, and 220. Now coming to the evidence of Panchanamas, separate Panchanamas, exhibit P27 is the Panchanama, The scene of crime wore a glory look with the bloodshed, so and so cut off body parts, scattered in intestine matters, scattered eatable materials, amidst of so and so, the cycles so and so due to explosion in and around explosion spot, existing business establishment so and so got damaged and disturbed. And again, paragraph 221, exhibit P28 is the rough sketch prepared by the investigation officer in the presence of the two panchas. P29 is another scene of offense drafted on 26/2/2013 in the presence of the panchas of so and so, and also what my lord the seized material, one burnt, damaged motorcycle and etc. My lord, this is all mentioned in paragraph 222. Exhibit P35 was drafted in the presence of the two panchas in so and so. My lord, the documents discloses with regard to seizure of materials as disposed by PW 49 Venkateshwarlu, that on 22/2013 so and so was on patrol duty, etc. My lord, what he has stated. 223 exhibit P36 is the rough sketch scene of offense in crime number of the police station Malakpet. 38 is the Caesar Panchanama in crime number 56 of 2013 of PS Malakpet, which discloses the following items were seized from the offense. MO 34 is the pieces of 9V battery collected from the scene of crime, marked as a Q1. MO 35 is the two broken SIM cards, 5 damaged V batteries, 2 small metal pieces collected from the crime, silver metallic pieces collected so and so and so. My lord, whatever is, my lord, I already read, my lord, at the time of reading, my lord, Venkateshwarlu's, my lord, the Panchanamas were conducted at the both places. What were the material, my lord, seized at the place? It was very clear. So therefore, and even inquest Panchanamas also discussed, my lord, paragraph 224. And postmortem report, paragraph 226. 227 is also postmortems. 228, the exhibit 141, MLC come injury certificates, my lord, of all the deceased persons as well as the injured, my lord. These are all very clearly mentioned, my lord. All again the paragraph the same. 231 medical certificates, 232. My lord, FSL reports, this is the most important, my lord. Medical certificates up to 233, 230, from 232 to 233 paragraphs. 234, coming to FSL reports. My lord, he has given the so and so items, ammonium nitrate and etc. And another, my lord, exhibit P88 FSL report, 235, my lords. And 236 also relevant. Photographs of so and so. And 237, the discussion. And another one paragraph 238, my lord, as for medical jurisprudence and toxicology, the electrical injuries caused by contact with electric conductors depends upon the kind of the current, the amount of current, path of current, the duration of the flow. The symptoms are there is no pain and the person becomes immediately unconscious, which may last for a few minutes and so and so. The skin explodes, rolls so and so. During the course of cross-examination, nothing was elicited except some minor omissions and contradictions herein which do not go to the root of the case or at least create any suspicion or doubt with regard to the nature of the blast as pleaded by the defense counsel. So moreover, 240, the reasons are assigned. So therefore, my respectful submission is paragraph 242 and 243. As of now, I discussed and decided the nature of the blasts, cause of deaths and injuries. Crucial question is, this is, my lord, due to the blast of the bomb, my lord. That is what they mentioned. So, as far as this aspect is concerned, my learned friend who vehemently argued that, my lord, that is also for days together, my lord. This is a clear application of mind by the court. And there is a finding of these paragraphs. So, my lord, the court has done. They have reproduced the entire evidence and cross-examination that was taken one of the ground by the defense counsel. It's not the simply, my lord, thereafter discussed. So that means, my lord, I am also submitting in such a way the court was of consciously know the evidence of, my lord, the total evidence as well as the cross-examination, which is the part of the judgment.
243 is the
Yes,
cause of loss.
yes.
Where is the finding?
It is there, my lord.
We got to second issue. Paragraph number 243.
Yes,
Trial court considered the reasons for blast.
yes.
Question is who caused the said blast and why? 243, paragraph number 243.
243. Yes, may I read? Now the next crucial question, who caused this said blast and why? This is case based upon the circumstantial evidence and defense of the accused is total denial. The case and contention of the prosecution brief, A1262 conspired to commit the bomb blast and so and so and so. Therefore, they decided to where was so and so. Thereby, at the instance of absconding accused number 1, accused number 2 to 4 came to Hyderabad by using fake ID proofs fabricated by accused number 6. At first instance, A4 took a rented house at Abdullahpur Med. Thereafter, A2, A3 came from Mangalore, joined A4. A2 to A4 went to so and so shop. A2 to 4 so and so. They purchased one plastic and etc. My lord, these are all the accused 2 to 4 waiting outside. Now, my lord, the paragraph 244, 243 end, my lord, I am reading. My lord. The improvised explosive devices planted by A3, A4 exploded at so and so, terror so and so, is the facts. Next. Whereas the defense of the accused is that the total denial. The entire defense revolves around the procedural lapses and irregularities committed by the land magistrate who recorded the confessions of accused, who conducted TI parade of accused, the district collector, executive magistrates, undersecretaries, doctors, and etc. Paragraph 245, as it may, the circumstances relied upon by the prosecution are as follows to connect the accused to the said bomb blast. Number 1, extracts of the retrieved online charting about placing of bombs in Hyderabad prior to blast, retrieval of online chart material during investigation at the instance of A2, A4 and A5, A4 Mohammad Tazeen Akhtar arriving from Ranchi to Hyderabad on the directions of A1 was in the knowledge of A5, and Mohammad Tazeen Akhtar coming to down Hyderabad prior to A2 Asdullah Akhtar, A3 Rahman taking the house and rent at Abdullahpur Met, and A2 A3 arriving from Mangalore. Next A2 A4 purchasing cookers and etc. Recovery of so and so and so. Well, nearly the 22, my respectful submission is
Circumstances.
up to 25. These are all the circumstances with regard to the incriminating, my lord, the material against them. Was also the court was of conscience. So, my lord, the other one, my lords, after 25, in view of the circumstances, court framed the following points for determination. These are the circumstances, my lord. The perusal of so. Now, my lord, every topic head, my lord, what the case of the prosecution. First, how? Paragraph 247, my lord. To prove the above circumstances, to connect the accused with the present crime, the prosecution examined the following witnesses. Yes, my lord. Owners of the Zephyr Heights at Mangalore to speak about the stay of accused number 2 and 3. 54, my lord, the protected witness, that is the owner, my lord. This is, my lord, no need to refer because your lordship is already, my lord, yes, I read, my lord. So therefore, 249 paragraph. Perusal of P55 subject to objection. There is a stamp of New Delhi District Court on each and every page, but it did not footwork and it was not issued by the District Court. During the court cross-examination, as usual, he let out the said portion in the normal course, stay in the same building. He stated he never found any illegal activities and etc. My lord, this is how, with regard to exhibit P57 is on. This is, my lord, the rental deed, my respectful submission, which was already proved by, my lord, fingerprint, my lord, handwrite expert also of the one of the, my lord, A2, Asadullah Akhtar, my lord, the Danis. Yes. And waiter at hotel. My lord, paragraph 251. Lordship got it? Yes. PW 65, Prashant Shetty, waiter, Jain restaurant near city center. He speaks about the description of the two persons. NIA police took so and so and so. shown the photographs in their laptop and asked whether they were visiting restaurant. He was the only person who can communicate in Indian hotel because it's a Mangalore, my lord. So this is already I read. So Ziaur Rahman, A2 and A3, my lord, they visited 4 or 5 months regularly. So therefore, my lord, the relevancy of this witness, the vote, my lord, waiter, that their presence in the house of my lord, the Zephyr Heights, that is PW 54 house, is also corroborated. Their stay is my lord there. They visited the locality of the hotel, my lord, some Jain restaurant. So therefore, my lord, the other one is during cross-examination what it was stated. And next, owners of the cyber caves to speak about the browsing of the accused. My lord, PW 69, but already that this browsing of so and so and so. Cross-examination, what was admitted by so and so and so. But again, paragraph 255, PW 70, Devara Sheth running a cyber cafe at Mangalore. So their evidence, my lord, with regard to providing services of so and so, my lord, the identity proof and etc. This was already, my lord, TA Parrot also, he identified, they said A2 and A3, my lord, they listed the cave, exhibit P69 is a signature in test TA Parrot, my lord, paragraph 256, cross-examination it was written, my lord, the no material contradiction was elicited, 257, PW 71 is also, my lord, running cyber cave, all, my lord, the exhibit P71 is also seized, my lord, the handwriting register maintained. The NI police asked the visitor so and so and so, identified two, Danish as A2 and so and so and so. He identified in TI Parade in 1910-2013, cross-examination, my lord. Investigation officer at Mangalore, my lord, PW 133, Deputy Superintendent of Police, my lord, as per the CIO, proceeds to Mangalore in the presence of mediators, so and so and so. They found a person by name so and so, my lord. This is all what the investigation part, my lord, yesterday regarding the investigations officer evidence, my lord, I submitted. And 260, paragraph, page number 227, online charting retrieval by ICERT expert. How, my lord, is stated before so and so, what were the exhibits marked 99 to, my lord, 107, and all how, my lord, the cross examination. Funch, my lord, again, page number 239, paragraph 263, funds for email extraction retrieval. My lord, these are the witnesses, PW 99, PW 140, paragraph 265, 266 is the cross examination, 267 is the re-examination, my lord. (274). Next, my lord, paragraph 275. Chief Investigation Officer in RC number, my lord, Delhi case, Vikas Vaibhav, what he has done, my lord, in this case, and what are the documents are marked. How, my lord, the Hyderabad conspiracy came to light. This is all is evidence. Paragraph 276 is the cross examination. And yes, my lord. Paragraph, page number 271 up to 271, my lord. And 278, PW 54, what you have stated regarding, my lord, the Abdullapur Met evidence. Paragraph 282, neighbors of the accused at Abdullapur Met. Paragraph 286, my lord, owners of Mahalakshmi Steel Stop. Paragraph 292, friends of A4. because A4 came from my lord the Pune, my lord, by taking the help of one of the relatives of my lord Mohsin Chaudhary, my lord, paragraph 292. PW 82, my lord, is cross-examination. 83 is the protected witness. Cross-examination, what it was stated. Next, my lord, 284, seller of cycle. 230, Malakpet parking contractors. 310, paragraph, my lord. Paragraph 310, page number 290, my lord. Paragraph 314, TV9 reporter. Paragraph 316, assistant investigation officer for fingerprints. Paragraph 318, punch for pointing out by A2. Para 322, CDFT expert for fingerprints. Paragraph 324, DMRL expert for metal pieces. Page number 311, paragraph 330, Western Union money transfers. Number 315, page number, assistant investigation officers, my lord. Yes, and up to page paragraph 358, 359, my lord, mobile shop owner who sold, my lord, one PW 102, page number 334. Mobile shop owner who sold the phone to A3. 335, punch witness so and so. All punch witnesses, my lord. This, my lord, the judgment I will give by each para and reference. If it is really only reproduction of the evidence also, I fairly write, my lord, this is. And what is the finding on that? So, page number 341, CFSL expert, my lord. Because who speaks about A3's knowledge of IED making? Because at Shamir Pate, the demo was given by my lord, accused number 3, Ziaur Rahman. My lord, 349. Eyewitness, this is the most important one, my lord. This was also under 349, page number 371, paragraph. Mergu Ailaya, PW 59. All VRL travels and the discussion, my lord, till punch witness and etc. My lord, sanctions, page number 372. Under secretaries 376. 402, punch witness of hideouts and etc. My lord, the IO evidences till page number 452. Yes. Page number 474. Yes.
419.
419. The land counsel for the accused tried to elicit contradictions and omissions from the charge sheet, but the charge sheet cannot be used for contradictions and omissions at investigation officers for the purpose of filing charge sheet, only for knowing indictment, but not for contradictions and omissions as contemplated under 145 Indian Evidence Act and so held. The land counsel for accused repeatedly contended as to why the TY9 reporter PW423, who claimed to have seen the accused number 4 parking cycle with cooker on its carrier, other circumstantial witnesses who claimed to have sold the cycles, cookers, and parking contractors who witnessed the accused number 2 to 4 taking away the cycle in susceptible manner did not respond immediately, so and so. Certainly, it is a reasonable question raised by the Land Defense Council, but the human tendency in our country is known to everyone is that generally nobody would come forward to give complaint to the police when crime is committed in the public. Furthermore, there are several instances the people as good Samaritans are not coming forward when crime took place. That is why Honorable Supreme Court so and so and so. That court cannot suspect their evidence by seeing with the aid of the spectacles fitted with the lens tinged with doubt, disbelief and suspicion. Followed 421. Credibility, trustworthiness of the witness. Almost all the witness produced by NIA are independent. Evidence is trustworthy. Their credibility is nowhere shaken in spite of lengthy cross-examination. On the other hand, there is a ring of truth in the whole of the evidence. Added to this, the most of the witness are official witness or forensic expert from the field of handwriting, fingerprinting, chemical analysis, computer data, learned judicial magistrates, district collector, undersecretaries from central government, doctors, other witnesses from the non-official cadre, who are the independent witnesses. They could identify the accused in spite of the best efforts made by the accused to disguise themselves by wearing same color dresses, sporting, veiled, putting on monkey caps, standing, sitting in their sequence, in shifting their place before identification of each witness, used to remove the same only after being asked by the court at the time of identification. Super added to this, nothing was attributed to them to give false evidence against accused, and the entire documentary evidence as produced by the prosecution is legally admissible. In fact, NIA has taken double care in securing documentary proof in as much as they have filed the primary evidence as well as secondary evidence in respect of electronic evidence. Before going into the discussion on the circumstances, clearly gave finding that death of deceased are homicidal. The injuries are caused due to twin bomb blast at so and so at Michuan Center. 422. Yes, Malad. 423. The prosecution relied on the following circumstances to connect the accused with the improvised explosive device bomb blast at A1 Merch Center, extract of retrieving chart, retrieved online, so and so and so. The Land Council strenuously argued prosecution failed to establish circumstances, so and so. 425. Land prosecuted evidence adduced by prosecution clearly establishes the complicity of the each accused, which makes them as a conspirators of the crime. In case of criminal conspiracy, the evidence would attract if there is an agreement between two or more persons to do or cause to be done an illegal act by illegal means. A criminal conspiracy would continue as long as the members of such conspiracy do acts in furtherance of the objects of the conspirators. Under section 10 of Indian Evidence Act, the offense of criminal conspiracy is complete where conspirators have agreed to do an act in furtherance of their common intention, such as the acts done by section 10 of Evidence Act. By any of them, which itself would be evidence, no specific overacts need to be established against each and every accused. In Ramanarayanam Poli versus so and so 2003 SEC, Supreme Court held that element of criminal conspiracy is an object or to be accomplished, a plain scheme of embodying means of so and so and so. Yes, Malad, I may be permitted to read section 10 of Evidence Act also for a minute, Malad. Your Lordship, book is not necessary, Malad. Things said or done by conspirator in reference to common design, where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense on an actionable wrong, anything said, done or written by any of such persons in reference to their common intention after the time when such intention was first entertained by any of them is a relevant fact as against each of persons believed to be so conspiring. so well for the purpose of proving the existence of conspiracy as for the purpose of showing that any such person was a party to it. My lord, Section 10 of Evidence Act, my lord, it need not be participated by all. My lord, in furtherance of the common intention, my lord, the very perusal of this section, my lord, here the section is missing. My lord, instead of 0, lordship may add it to 10, my lord. The paragraph 425. In our book, it is there. Yes, obliged. And this is how. And regarding, my lord, the conspiracy aspect, 120B, my lord, the last 4 lines, my lord, of the same page, page number 477, for an offense punishable under section 120B, it would not be necessary to give direct evidence of an agreement of conspirator, but it can be proved by certain implications and inferences can be drawn from the perpetrators. The conspiracy can be proved from the circumstances of the case, indicating the meeting of the minds. Honorable Supreme Court in Khalid versus State reported in so and so that no overtake need to be proved to establish criminal conspiracy when existence of an agreement to commit an act can be shown from the circumstances of the case. In the judgment reported in 2001, so and so and so, Supreme Court observed the rationale of conspiracy is that required object to manifestation of deposition of to criminality is provided by the act of agreement. Conspiracy is a clandestine activity. Persons generally do not form illegal covenants openly in the interest of security. A person may carry out as part of conspiracy without even being informed of the identity of his co-conspirators. Since an agreement of this kind can rarely be shown by direct proof, it must be inferred from the circumstantial evidence and cooperation between the accused. Para 24, the law has developed several different models which has to approach the question of scope. One such model is that of chain, where each party performs a role that aids succeeding parties in accomplishing the criminal objectives of the conspiracy. No matter how diverse the goals of large criminal organization, there is but one objective to promote the furtherance of the enterprise. So far as the mental state is concerned, 2 elements required by conspiracy, that they are intent to agree and the intent to promote lawful objective and conspiracy. It is the intention to promote the crime and lends conspiracy its criminal cast. Para 25, conspiracy is not only a substantial crime, it also serves as basis for holding one person liable for the crimes of the others in cases where application of the usual doctrine of complicity would render that person liable. Thus, one who enters into conspirational relationship is liable for every reasonable, foreseeable crime committed by the other member of the conspiracy in furtherance of its objectives, whether or not he know the crimes in either their commission. The rationale is that criminal acts done in furtherance of conspiracy may be sufficiently dependent upon its encouragement support of the group as a whole to warrant the treating each member as a causal agent to each act. Under this view, which the conspirator committed, the substance of offense would be less significant in determining the defendant's liability than the fact that the crime was performed as a part of larger division of labor to which accused has also contributed his efforts. Although it is not in doubt, the offense requires some physical manifestation of agreement. It is important to note that the limited nature of proposition, the law does not require the act of agreement to take any particular form. The fact of agreement may be communicated by words or by conduct. That is, has been said, it is unnecessary to prove that parties actually come together, agreed in terms to pursue the unlawful object. There never had been an express verbal agreement. It being sufficient, there was a tactics understanding between conspirator as to what should be done. The Supreme Court has given the wider interpretation with regard to section 120B of IPC and clearly held in this need not be a physical meeting or otherwise a direct involvement. Even there to promote their ultimate, my lord, the ultimate goal of, my lord, the illegal activity is an important. How they are performed is also immaterial. My lord, so my respectful submission 426, being the owner of cyber cafe at so and so, used to come to cafe so and so. These are all cyber cafes, my lord, 426 so and so and so. And some of the code languages which, my lord, the accused has used, code language words, paragraph 430, that they confess in disclosure memo, 164 statement, as well as, my lord, the court also has taken, my lord, the perused all these, my lord, exhibits 430. The following material was revealed as per the evidence of PW 138. Though online charting that 28/11/2012, my lord, lordship may see, prior to the blast. The accused number 5 explained that H means Hyderabad. Lot of anti-Muslim activities are going on. They discussed that the place has to be targeted, for which accused number has given the task to carry out so and so. Lord, the other thing is, all what they have, my lord, earlier I read, my lord, how they prepared, how, my lord, they moved together, my lord, how they are charting and the plan and conspiracy till 21st 2013. And my lord, 431 paragraph is DSP Kanakraj, my lord, who registered, seized some of the registers of, my lord, at Mangalore, my lord, certain I already submitted. And the other, my lord, things are concerned. The paragraph 432 is witness PW 82 Ranchi, my lord. He was staying in adjacent to Chotu Lodge. He was saying there was conversing regularly, informed that he wanted to do ME, tried to give so and so and so. My lord, he identified Samir as accused number 4. He was studying in diploma. He gave the address and phone number. Samir went to Hyderabad, met his cousin. He was also examined, my lord. These are all PW 13, 14, VRL travels. My lord, paragraph 436, PW 64, Mangalore. My lord, these are all the financial transaction. PW 127, booking clerk. My lord, 438, paragraph 60, auto driver. My lord, he has also seen in so and so and so. My lord, 7, purchasing cookers and etc. Bicycles, identification, MOs. My lord, paragraph ships. Yes, the reasoning, my lord, again 463, paragraph 463, 63, paragraph 463, 502, my lord. But 461 is also, my lord, the discussion, but straight away what exactly the counsel for accused strenuously argued that this case is only a consequence of alleged conspiracy to commit various blasts in the country, like Varanasi, so and so, Bombay train blast, Lumbini blasts, Indian Mujahideen, including Dilshanagar, so and so. The present case is only a consequence of such alleged conspiracy. As such, from any angle, the charge number 1 in respect of the charge of conspiracy framed in this case utterly fails, as they have been charged on the same provisions in other 2 aforesaid cases at New Delhi, added to the concept of double jeopardy as enunciated in section 321 of, my lord, the Indian Constitution. Chief IO so and so. My lord, the discussion is section 300. Person once convicted of so and so, my lord, the paragraph 465. Therefore, there is no bar to frame charges against accused, even though similar charges are framed in other cases, Delhi. Moreover, the conspiracy under section 120B taken from 2000 to 2013, where the conspiracy and other cases might have commenced long ago. Moreover, this offense may not be taken into consideration by these other courts. Anyhow, section 300 attacks only when there is a previous acquittal or conviction. And one important aspect, my lords, even the other cases of the blast, either RC6 or FIR 154 of so and so, Jama Mahdi's blast and Best Bakery and it's whatever they mentioned. The charges of Hyderabad blast with regard to Sarur Nagar police, in police station case, and my lord, the Malakpet. Nowhere it is, my lord, the charges of those cases. So there is no any double framing of charges. My respectful submission is. So if really the charges are the part of that, my lord, no investigation was carried here. No, my lord, my respectful submission, if really this is the part of that case, the place of offense, the blast, the seizures, the panchanamas, all should be conducted by that investigation officers. It's not the part of, my lord, those cases. So moreover, there is a long lapse of time, and my lord, just now the Supreme Court has clarified that, my lord, my respectful submission is a conspiracy, my lord, it ends when the, my lord, the conspiracy design of the conspirators, my lord, is completed. Their acts, my lord, with regard to Delhi, one act is over. My lord, the other is so and so and so. So therefore, land councils arguing that all the best for 10 years or 15 years cannot be, my lord, my respectful submission is. So the court has given the finding. So this is paragraph 466 also what I argued. The court, my lord, has also now the question, this court made an inquiry with regard to letter addressed by the accused, alleged missing of charge so and so RC number 6, which is containing only 2 pages marked as a D. For defense counsel said only said pages are available in record. There is no true in the allegation land counsel for the accused. Exhibit D40 shows that it contains 2 pages only. It has been true about the missing of the charge sheet, certainly so and so and so. But the perusal of evidence of so and so, paragraph 469, the discussion about the section 24 to 27 of Indian Evidence Act. The discovery, the pointing out of A2, A3, A4, A5 and A6. So, Lordship, I may be permitted to read on this aspect what is the counts, the arguments of the defense counsel. The paragraph 469, the land counsel for the accused raises another contention with regard to evidentiary value of the confessions drew my attention to section 24 to 27 of Indian Evidence Act. He further contended that accused not was in custody in this case and those recoveries need to be proved in Delhi case. Therefore, the recoveries are not admissible in this case. He further contended that exhibit P 259, 261, 152, 157 and etc. up to 492 have been proved in Delhi case only but not in this case. He relied upon a decision so and so and so. It is also utmost importance to mention statement of PW15 regarding the seizure of car, since it is reflect to how casually with what so and so. There is no bar to take the evidence of another crime to this case. Therefore, this decision is not applicable. My lord, as far as my lord, my submission is the use of the crime papers of one case in another crime. My lord, it is permissible. I will also place, my lord, judgments I am giving tomorrow. That aspect is very clear by the Honorable Supreme Court. And more so, the investigation officer, the prosecution agency has only connected that these are all, my lord, in the catching of the conspiracy of at the various places, my lord, they are already, it is, my lord, they are already doing at various places and also at Hyderabad. Their criminal activity, how they moved and how they came and all these things. So therefore, paragraph 470, this is all. That is that aspect. Special public prosecutor submitted, keeping in view of the continuous acts of terrorism carried out over the period of 7 years by the accused, other belonging to banned organization Indian Mujahideen, a crime in RC number so and so. Investigation was being carried out pertaining to overall the larger conspiracy of the bombings throughout India. Individual crimes were booked and investigated into places throughout India where the blast took place. RC6 are the details of all the blasts were carried out throughout over a period of time. The investigation officer Sunil Emmanuel, PW 138, is one of the officers investigating in the both cases, RC and present case. Any investigation done in RC which is investigated for larger conspiracy of Indian Mujahideen will also form part of individual crimes booked throughout India wherever the terrorist activity is carried by A1 to A6, show the other members of the banned organization. Investigation carried out in RC number 6 of so and so pertaining to the present crime forms part of investigation done in RC number 1 pertaining to Dilshanagar blast, Hyderabad. Confession, extractions of electronic charting collected during the course of investigation can be used in whatever the evidence produced during the course of trial, which forms of only actually pertains to Dilshanagar blast. Documents in the filed court are part of RC number. The investigation officer who conducted the investigation being tried in the present case are all part of so and so. Therefore, no prejudice is cast in the part of so and so is caused in evidence collected in filing into this case is also relevant. He relied upon the decision 1997 SC Rajasthan so and so where it was held. It is clear from the above evidence the public witness to discover the fact respondent has buried article so and so, his statement to the police had buried despite so and so, therefore gets extricated from the ban contained in section 25 to Evidence Act as it is becomes admissible under section 27. Contradictions prescribed in section 27 for unwrapping the cover of bar against admissibility of statement of accused have been satisfied. So and so, my lord. It is immaterial whether inference so and so crime or a different crime. Fact discovered by the police. Article 4 so and so. Section 106 of Evidence Act, burden of proving fact especially within the knowledge. When any fact is specially within the knowledge of any person, the burden of proving the fact is upon him. The section is an exception to section 101, which lays down the general rule that in a criminal case, the burden of proof is on the prosecution. This section is designated to meet certain exceptions in which it would be impossible for prosecution to establish the facts which are especially within the knowledge of the accused and etc. The section cannot be said to strengthen the evidence of prosecution so and so. With regard to recovery under section 27, reads as how much of information received from accused may be proved so and so. The statement is admissible in section 27, my lord. The all regarding this is the discussion. 475 is also 476, 477. The judgment cited by my lord, both the prosecutor as well as my lord, the accused. 479. All this is, my lord, yes, 482, my lord. Paragraph 482. This court deducted the following principles basing on the above decisions. There must be a discovery of fact, albeit relevant fact in pursuance of information received from a person in police custody. The discovery of fact must be disposed at the time of giving up the information. Accused must be in police custody. It is immaterial whether information was supplied in connection with the same crime or different crime. Then the effect is on much of the information relates distinctly to the fact, thereby discoverable is admissible. For example, so and so. Lord 483. In the present case on hand, the following are the discoveries under section 27 of Evidence Act. Lord exhibit P55, that is at the list of A2, Mangalore, the Heights, CRPF campus. Lord, this is clearly mentioned how let under section 27. So therefore, paragraph 484, in the case all the above said discoveries were established by the prosecution beyond the reasonable doubt. Yes, ma'am. The discovery again, the discussion, my lord, again 487, 164 CRPC statement that, my lord, I already submitted, and other one is TA parent, criminal rules of practice, my lords, sorry, paragraph 482, rule 31, 32 of criminal practice, requisition for confessions, my lord. Confessions already I submitted, I read 164 and the procedure and also the relevant, my lord, the documents marked. And 418, 491 also 164 statement. 492.
164.
Yes, my lord. And 493. 330 statement, my lord, how it was written and etc. 494. The following are the relevant portion of confessions of accused number 2 and 5 and etc. my lord, what they have stated. 496. At this stage, accused number 2 filed a petition and the same is numbered as a criminal miscellaneous petition. The brief affirmation are said they were tortured by NIA officials during their custody. NIA official threatened to give a statement in front of the court that NIA officials gave statement and written and forced the accused to say this so and so and so. Judge thereby requested for retracting the confessional statement. On the other hand, my respectful submission is here, the relevant to submit. The confessions were recorded long back by the land magistrates. But the land council has kept quiet silent for many several months. When these the confessional statements, the evidence are recorded, when the court is taking into consideration this evidence, then he filed a malata. Till then, he has not taken any steps. Really, confessions are by force. They would have challenged it, malot, by way of 226 or 482 or whatever, the change of investigation officer or investigation agency or otherwise, they would have informed to the magistrate 164. Malot, there was already record, malot, the questions were there. Yes, I am giving voluntary. And the magistrate also warned, if you give any statement that is going to against you also, then that said they know about that. After several months, filing a retracting statement, my lord, is only deliberate one, and more so, just my lord, the 164 was recorded under the due process of law by following the due procedure. So therefore, at this juncture, the counsel for defense cannot take that, my lord. And nothing is afterthought. My land, my lord, the counterpart in 497 paragraph, he also said so and so and so, my lord. Retraction of confession is concerned. Paragraph 500 is a discussion, my lord. 501 also. Section 30 of Indian Evidence Act. My lord, I may be permitted to read Section 30 of Indian Evidence Act, paragraph 501. Consideration of proved confession affecting person making it, others jointly under the trial for offense. When more person that one are being tried jointly for the same offense, confession made by one of such person affecting himself, some other of such person is proved, the court may take into consideration such confession as against each other person, as well as against the person who makes such confession. It was held in State versus Nalin. Honorable Supreme Court dealt with the length, my lord, Section 30 of Evidence Act, my lord, the confession with regard to so and so and so, the nature of the, my lord, the confessions and etc. And 505, Andhra Pradesh High Court, Shakamuri Apparang, my lord, versus Government of Andhra Pradesh, for offences under Act so and so and so, for Arms Act. Evidence adduced by the prosecution against stage was PW4 intercepted so and so and so. This is Honorable Supreme Court in paragraph 506. Radha Kishan, State of UP and so and so. This case also not accepted by the trial court. My submission is all these citations which my learned friend has submitted. The court came to conclusion that this is not applicable. What more can be written? The genesis of the judgment, the gist of the judgment, the ratio of the judgment, my learned friend has not mentioned how a particular aspect is disproved or otherwise vitiated to that extent. That is not there. So my learned friend argued, no. He mentioned, the trial court judge mentioned the judgment and simply said, no, it is not applicable. He said it's not applicable simply to the facts and circumstances of the case. So, only for the sake of argument, my brothers, with great respect to all my three brothers, they are very, made every effort by way of submitting judgments. But of course, the trial court has given the reasons. So therefore, the reasons assigned by the trial court is fully, in fact, is applicable in this case, and all paragraphly applicable. This is what I am saying. The reasons given by, but the citations are not applicable. Paragraph 512, all, and my big, my lord, my respected, my lord, my elder brother, Mr. Mahadevan, my lord, almost from 1952 to my lord, 2012.
Identification slips.
Yes, that is already identification slips. I already argued.
Ending is at page 520.
I'll argue, my lord. With regard to judgments, my lord, I submit 3-4 sentences. My lord, almost every judgment, my lord, every judgment having its own ratio. But whether, my lord, the purpose of, my lord, citation is whether the ratio is applicable to the facts and circumstances. My lord, the counsel appearing, either the prosecution or defense, must point out to under what aspect it is squarely covered. So, my lord, citing so and so, my lord, every citation, my respective submission, it has some, my lord, ratio. My lord, ratio, decidency or whatever, my lord. But simply saying, I am also agreeing what Supreme Court said. But whether it is, my lord, this is applicable to or not, it is for the trial court or this honorable appellate court. So my learned friend has not pointed out exactly with certainty under what aspect, under what circumstances, under what the observation is vitiated, my lord, the court has not applied its mind. That was not done. So all these, my lord, even the trial court, my lord, was, my lord, I can say that, my lord, has given a lengthy, my lord, hearing and time also. Every judgment has fairly, my lord, recorded in its, my lord, judgment, whatever is cited. Generally, my lord, it is for the court whether to decide applicable or not. But to the utmost fairness, they have written, my lord, anything. But even in the course of arguments, my learned friend with regard to the judgments, he said, no, sir, I'm giving 2 volumes of judgment. Your lordship said, give the relevant. Your lordship has equally directed the accused as well as the prosecution. So, my lord, it is our endeavors to satisfy this court. If really, what exactly the legal position, under what circumstances. So, therefore, my lord, regarding the 513, my lord, 100, this is, my lord, the search and seizures, my respective submission, 103, 165, police officer and etc., paragraph up to 517. And all this, yes, my lord. So this is all the search under 165, my lord, all these hundreds and 103 of section CRPC, my lord, that was already all the searches. What exactly the cross-examination? All the searches in the presence of the independent witnesses, all exhibits are before this honorable court. More than 507 exhibits are before this honorable court. I am drawing the attention, my lord, I am not skipping every page, my lord, to the fairness, my lord, either defense or prosecution, my lord, my respectful submission. Every page, my lord, though it is consuming time, I am troubling your lordship because my respectful submission, lordships are human beings. My lord, reading every page, every line is also difficult, but still, I am placing before your lordship what every sentence of the court or the trial court. So my respectful submission is there are no illegality or infirmity or, my lord, any, my lord, so illegality in these searches and seizures, my lord. So my respectful submission and my counterpart in page number 520, the public prosecutor, my lord, AP police manual. It was clarified in the court below. My learned friend, my lord, has to say, I am telling the counter arguments of both sides. I am not choose and pick and choose policy. Well, at 520, what I submitted that the manual. So there is no bar, any police officer, but only condition is DSP, subdivisional SDPO, at least DSP rank. So the framing of this subordinate rules, the approval by the competent authority is for fairness of the investigation, that is by DSP. So nothing is attributed, all Zephyr rights, etc. And 523 and paragraph, the scientific experts, paragraph 524 under section 293. ICRT is a lab Gandhinagar FSL is a lab, Karnataka is a lab, Ramantapur is a, my lord, the forensic science laboratory is a recognized lab. These are all, my lord, run by the government, particularly are competent to give evidence, and no such notification, my lord, declaring these are not as not filed. My lord, if either prosecution or defense, my lord, they stands on equal footing. If really disputing something, it is for them, my lord. That is why the concept of the defense evidence. That is the concept of, my lord, the cross examination. Nowhere, at no point of time, more than 1 year and, my lord, 6 months trial has taken place. Nothing has been filed before the trial court. Yes, my lord. So, my respectful submission, 526, 70B, Lordship Mazy, 525, E further contended ICERT does not come with 79A so 60 by certificate. For use of 70B, my lord, the court also gave finding. These are all exhibits.
70B అయిపోయింది టెస్ట్
Yes.
కూడా
Not the 70B, my lord, I'm again
we have completed that.
again I'm reiterating, my lords, it is not like a lab. Not the 70B, well, that's ICRT assistant, PW 81 Subramanya Babu. We have taken the assistance of that expert because he is from so and so ICRT. He is a scientist of so and so with due qualification to extract, because the presence of accused, because it's a pointing out memo, extraction is possible with the presence of accused. In the lab, it is not possible. So only to the extent of the job done by PW 81 and IO in the presence of the independent witnesses, with the pointing out by the accused so and so, that only what are your email IDs, what are your so and so, opening and screenshots. Why lab? It's not a lab. It's not a lab processing. My learned friend Mr. Patan, A6 argued that this is declared in 2020. It is in 2020. Yes, I too agree. Lab is different. Extraction, taking assistance of the very 70B, which is incorporated in 2009. Well, that is for the purpose of analysis as well as so and so. They would have challenged this section. That section authorizes. So therefore, followed by 65B, all exhibits 460, followed by exhibit P83, etc., 85, again 107, all these I read, my lord, I don't trouble your lordships, and 527, 528, and all these. And again, my friend has not, my lord, left the trial court 529. Again, he said, at this stage, land counsel for accused, electronic evidence was not played in the court. This is only the papers which we extracted.
The court below, trial court relied upon section 22 capital of the Evidence Act and is the file.
My friend argued, again it was not played in the court. Would have filed, my lord, a requisition or at least or something, really, if by the time of trial.
That is with regard to test identification parade.
Yes, my lord.
And findings are also there.
Yes, my lord. All 34 regarding rules 35, 35, my lord, identification parade. Of course, my lord, the trial court has done small things, my lord. Instead of, my lord, reproducing the entire evidence, so and so, it would not have run to 750, 740 pages. My learned friend only took some 15, 20 pages. All these 20 pages are like this. So, my lord, I'm saying that I'm not finding any fact.
554. 554. 554, page number 554.
Yes.
Above the paragraph of 544. In the present case on hand, also no latches can be inferred, though there is some delay which is ignorable.
Yes, 554, my lord. Honorable Supreme Court said so and so. I'm sorry, page number 554 or paragraph, my lord, lordship referring?
Page number 554.
554.
The paragraph, unnumbered paragraph before 544.
Yes.
That is with regard to
yes
latches.
Yes.
Which can be ignorable.
Yes.
With regard to test identification parade. Right? Then, then trial court also relied upon 4-5 judgments.
Yes.
And gave finding.
Yes. And even the Honorable Supreme Court, the number of my lord, the empty cases and catena of cases, even my lord, the purpose of my lord, the identification parade is only my lord, the corroboration, but to substantial. My lord, the identification of the court is also the main thing.
566.
566, my lord.
Page number 571, paragraph number 576. Court gave finding with regard to identification of accused by the witnesses, right?
Yes.
Then you have to read 567. This is with regard to jurisdiction of the magistrates who recorded.
Yes. Yes, my lord.
567.
Yes, 567. Crimes in the case one cause Sangareddy, one is the Saru Nagar Rangareddy, nominated by the superior. Then course of accused
Non-examination of
non-examination of the
record.
Honorable Supreme
That is
Court
not a
judgment is there. It's 164. You know, that court also observed in Bashubaka Lakshmaya versus State of so and so. It is not
There is
necessary to call the magistrates.
one recent judgment.
Yes, yes. Even the other way, the judgment is also not the earlier judgment of
Validity of sanctions 575.
Yes, my lord.
Paragraph number 575.
Lordship has gone 575.
Validity of
Yes, my lord. Validity of sanctions, I said.
with regard to identification, trial court has referred about 10 judgments. There is one judgment, recent judgment we will rely upon.
Yes.
575 is with regard to validity of sanctions. Right?
Yes. Sanctions I already submitted with reference to so and so and so. And
in 583, 65 of evidence act, 650, 65 capital of evidence.
yes, 65 Evidence Act. Originally shown so and so. One of these, the documents marked in RC6 is a certified copies of the court. It bears the the stamp, seal of the court. I also pointed out electronic evidence, that is already, the legal portion is there. Who will dispute? This is the law of the land. Nobody can dispute. Yes.
Then please come to 597, paragraph number 597.
Yes, Malad. Further content live electrical wires. There are kitchens, including gas cylinders. But that is also.
Mr. Mahadevan, sir.
May I say one thing? May I say? Malad, this is an area where the A1 mixture center is there. Some electric wires because the poles are there. But the crucial material which is used in the blast, it is by way of FSL evidence, by way of the place of offense, what the material was seized, that is proved. It's a blast IED. Again, the electrical and etc. wires will be there everywhere.
Come to 598.
There will be no street without electric wires. There only except Abdullahpur met that Hilak place. That we can find 599 Malads. He further conducted, there is no material like Patso, Bolso. It is for these clients. They I can't say.
599 is with regard
CRF headquarters.
599.
Yes, my lords. That is CRP headquarters, highly secured place. There is no so and so and so to cooperate another department. There is no proof expected from the prosecution. I already said these are all comes under Minister of Home Affairs. And even under RTA also you can apply whether any permission. No, what I'm trying to say. Really is disputing. Silence is, of course, is always one of the fundamental right. But every time accuser silent is also one of the prosecution case affects them. Sometimes they have to produce defense evidence also. He further contended, scene of observation. Next, jurisdiction, that aspect is over. Jurisdiction I already submitted. The Dr. Srinivasarao appointment for the both states. NI is a police station for the entire country. Not country, beyond even the overseas.
603 with regard to jurisdiction of the designated court. 603.
Yes, Malad, yes. That is there in GO also, Malad. That is GGO. He challenged that also, Malad. I'll place because of long, Malad, since long The officers left, so therefore they are unable to get these all. I'll definitely collect, my lord, by within 2 days. Almost these are the what they have filed, what are the affidavits of that they filed writ petition challenging the appointment of this court also. It was dismissed, my lord, at the very admission stage. SLP was also filed. That was also dismissed. They made every legal effort.
You have to produce all those.
I produce.
Then 608. 608.
Yes, my lord.
Online charting
Yes.
between accused number 1 and 2, 225.
Yes. These are all I submitted, my lord. All online charting.
And don't watch him. And don't watch in the judgment line.
Over? Yes, page number 628. Almost climax, my lord, 628, the last few pages. Page number 628, paragraph 664. Let me now this court, 663, to examine whether the charges framed were proved by the prosecution beyond the reasonable doubt, basing on the above proved circumstances. 662 is circumstantial evidence discussion, and all this is, does the prosecution prove that so and so and so? If so, what are the explanation? My lord, all this is answers the observations by up to page number 657. Again, my lord, repetition not necessary, my lords. Again, 669. All charting and etc. Everything, my lord. Yes. My lord, the 703, my lord, is the last one, my lord. Paragraph 703, page number 670. 670, paragraph 703. No doubt the prosecution established that accused committed terrorist activities to wage war against the government of India, failed to establish by filing the notification under so and so Indian Mujahideen unlawful organization. Consequently, mere proof of member of organization does not attract so and so. So and so, therefore, prosecution beyond all reasonable doubt 2030 so and so. In the result, the accused two are found guilty for the offence 120B, 320 so and so and so, 120 so and so. These are all more on the findings of guilt, and also the quantum of sentence and judgments I'll submit tomorrow.
Tomorrow.
Because citations are there, judgments.
So tomorrow you are going to conclude.
Yes. Yes.
God save. So what about your reply? You have instructions from Mr. Mahadevan. A4 anyway, you said same ordinance. Huh? So then make your submissions tomorrow, A4.
That also.
That you can give the note. International law applicability, please give note. And with regard to A4, make your submissions tomorrow.
Then I'll finish tomorrow, my lords. My lords, I'll finish tomorrow.
Tomorrow you have to finish, he has to finish in respect of A4. Last time he said nothing. He's adopting arguments of A3. Is it not? Inke special gain level.
Nothing. Joint.
Huh? So Kabati, so tomorrow he is going to finish, and we will also say you have argued on behalf of A4. Then if any reply arguments are there, inform Mr. Mahadevan so that we will hear him day after tomorrow. We will hear him tomorrow, day after. But this week you have to finish. This special bench is disturbing other matters. That is the problem, right?